State your last name.
Morning, Your Honor. My name is Mark Tinsley.
Mr. Tinsley, how you doing today?
Good.
Very quickly, you understand, obviously you're a lawyer, you understand we're here for some in-camera proceedings, so we're not going to go into every bit of background and detail that we would where you testify before the jury. You understand that?
I do.
I do want to, though, kind of move through quickly some of the subject matter that the state proposes to put before the jury. But very quickly, if you would, just quickly tell us what you do for a living and what kind of practice that you have.
My name is Mark Tinsley. I practice law in Allendale. I have a fairly statewide practice, primarily personal injury, plaintiff's work.
All right. And how long have you been practicing in Allendale?
Since 2000, so 22, 23 years.
You have a statewide practice, or is it primarily?
To the extent I want it statewide. I mean, I handle cases statewide if I'm inclined to handle those.
Okay. Primarily focused in the 14th Circuit, is that fair?
14th and the 1st.
Yeah, the first. Okay. Do you know the defendant, Alex Murdaugh?
I do.
And how did you get to know him?
He practiced law in the adjoining county. I had a number of cases with his firm, small bars in the two counties, and known him since shortly after I came to Allendale.
And do you know other lawyers in the what used to be known as PMPED firm?
All of them.
And are those individuals that you may have had cases with, or just generally in the same line of work with over the years?
Yes.
I want to take you to February 19, and are you familiar with the boat case?
Unfortunately.
And do you represent the Beach family in the lawsuit related to the death of Miss Mallory Beach?
I do.
And ultimately, you ended up accepting that representation and filing suit against a number of defendants, including the criminal defendant here, Alex Murdaugh. Is that
I did.
correct? Okay. Tell the court just very quickly who the defendants that you sued, at least initially, at when this case started.
Mr. Waters, my recollection is that I sued Alex Murdaugh. I know I sued Luther's, which is a bar downtown in Beaufort. I sued the Woods, which was where the kids had gone for an oyster roast. I sued the Murdaugh Family Trust, which owned the property where the boat was launched from, and we believe that there could have been some drinking that went on there. I'm not 100% certain in the first lawsuit if I sued Buster Murdaugh, which is Alex's son, but I think those were the defendants initially.
Okay.
And maybe Randolph Murdaugh personally as well.
Not long after you started the boat case, and well, let me ask you this. Did your client, Renee Beach, have any particular experience at the scene that informed how you were handling this particular case as you went forward?
She certainly had an experience that prompted the call to me.
Okay. And can you explain that to the court, please?
She wanted to go down to the bridge where the boat crash had occurred. I think this was either Monday or Tuesday, so the crash happens early Sunday morning. The scene's cordoned off, and she's told she can't go down there. And just a few minutes later, Alex's father and his wife pull up in a car, and they're waved under the tape, and they go down to the bridge. And she was very upset by that.
Okay. And did she, in your discussions with her, did she give you any particular instructions about proceeding forward in this particular case as part and based on that experience?
No. Nobody really gives me instructions.
I understand. All right. Not long after you get involved in this case, did you have any chance to review and look at any insurance coverages that may be available to the defendant?
My recollection is within the week, certainly 2-week kind of time frame after the boat crash, Danny Henderson, who was handling the boat crash as Alex's personal lawyer, brought me all of Alex's insurance policies. And so I reviewed them at that time before I filed the lawsuit.
And what was the purpose of you reviewing those policies?
In a civil case, the only thing that we can do to try to, under the law, make a party whole is recover money damages. And oftentimes when we are drafting lawsuits, we will try to draft the initial lawsuit to make sure that there's insurance coverage. So that was the reason I wanted the coverage. And beyond that, sometimes, like I did with some of the initial defendants, you can, because of the circumstances, because of the culpability, how bad the liability is, how catastrophic the loss is, many times insurance companies can be leveraged to pay their insurance out, to get these people closure. No amount of money is going to make them whole. So the best that we can do is try to get them some closure and help them heal.
All right. And when did you determine, as you looked at what coverages were available to Alec that potentially could be relevant to the boat crash?
Well, so there was $500,000 that Progressive had on the boat. It was a watercraft policy. Although I've never seen the policy, that insurance was offered almost immediately to all of the victims, not just the Beach family. There were 2 other girls on the boat and 2 other boys, and including Paul Murdaugh. And so when I reviewed the policies, it was apparent to me that there was no possibility that any of the insurance that he had at the time of the boat crash would apply to this. And if there was a possibility, it would be limited to an idea that Alec was negligent in allowing Buster to give Paul his duplicate ID that he had made so Paul could purchase alcohol.
Did Alec have a policy, an umbrella policy with Nautilus at this point in time that was available?
He did not. He had.
And explain that to the court why that was not available, please.
It appeared from review of the records that there was an open claim when the policy came up for renewal, and that open claim was the Satterfield matter, and that it was Nautilus and I think Lloyd's of London, and they would not renew the policy, and so he had to then seek other coverage, and what he ended up was with Philadelphia, and it was a commercial hunting operation policy that contained very broad watercraft exclusion. So they even barred a negligent entrustment claim as it related to a watercraft.
And that Philadelphia policy depended on Moselle being considered as a commercial hunting lodge. Is that correct?
Not only Moselle, but the occurrence, in other words, whatever it is that causes there to be coverage had to arise out of a commercial operation, as I read the policy.
Realizing that as it related to Alec, specifically, was he essentially underinsured as it related to what the recovery you were seeking in this particular case?
Oh, absolutely.
Right. And what was your ultimate goal, though, in seeking recovery as it related to Alec in this case?
Well, it changed over time. And I mean, initially, I believed that the case would settle. I didn't see how people could ignore the significance of the loss, the public support of the community for the Beach family, and then the hue and cry as it related to the liability and the Murdaughs in particular. And so, it changes over time, but the one consistency was to get the case resolved.
Okay. And did you make it clear to Alec's attorneys that you were seeking a personal recovery that he would have to pay as opposed to just accessing when insurance coverage was available?
Always.
And that was consistent all the way through, is that correct?
All the way through.
Were you making substantial demands to the defense that Alec pay a substantial recovery personally?
I think by most standards, and I don't want to seem crass when I say this, but the Beach family stood on the causeway for 8 days while their daughter's body was in the water. I don't know that there's any amount of money that somebody would willingly take to go through what they've gone through. But if you were asking a lawyer who does civil work, was I making a substantial demand in terms of a settlement? I think that most people would say yes.
In your assessment, did that come as a bit of or did the defense express to you surprise that you were seeking a personal recovery from Alec rather than just simply trying to access what insurance coverage he had?
Yeah, some people did. John Tiller was primarily handling the case for Alec, and I didn't get that from John, but I got it from a lot of people.
In August of 2019, is there a particular conference that those in your line of work go to?
It used to be called the Trial Lawyers Conference, but yeah, it's in Hilton Head, and I went in 2019 of August.
Did you see the defendant there?
I did.
And did you have a conversation with him about the boat case?
I did.
All right. Can you relate that conversation to the court, please?
Yeah. I think, I'm not 100% certain that it was a fundraiser either for Mr. Harpootlian or it was a fundraiser for Lindsey Graham. As you come into the hotel, there's a gathering area. It's in the evening before everyone goes to dinner, or it's immediately after. I'm not 100% certain. But the room's full of lawyers, and Alex sees me, and he comes across, and he gets up close in my face and says, "Hey, Bo, what's this I'm hearing about what you're saying? I thought we were friends." And I replied, "Alec, we are friends. If you don't think I can burn your house down and that I'm not doing everything and I'm not going to do everything, you're wrong. You need to settle this case."
Okay. And so what was the point of that conversation? What was, if you can explain to the court what y'all were talking about, what is Alec upset to as you understood it?
That he was going to have to pay was what he was hearing. That's what it was. That's what the point of it was. We're friends. I took it as he tried to intimidate me. He didn't intimidate me. And sort of bully me into backing off.
Was there a mediation in September of 2019?
There was. No, 20. September of 20.
Before we get there, we move into early March of 2020, and we probably all know the answer to this, but what happened in March of 2020 that kind of changed the world?
COVID, the court shut down.
And did that have an effect on slowing down things in the court systems?
It definitely stopped the court system. We continued to take some depositions, primarily law enforcement. It was at the scene early on, and then ultimately, when everything finally shut down, I'm not sure if it's May or April, when then we were sort of confined to our offices.
Did you, during the course of COVID, take the opportunity to sort of present the case to a mock jury to get an idea of how that jury might respond?
I did.
And were the results very favorable for your client and not favorable for Alec?
They were.
Okay. Did you ultimately communicate that fact to the defense?
I did.
Had you come into possession of some social media videos that you believe would be very advantageous to proving your case and achieving a large recovery?
I did. And I shared those with John Tiller.
Let me get something marked real quick. We'll show you what's been marked as Exhibit 401, State's Exhibit 401. and see if you recognize that document.
I did. I do.
Right? And what is that document?
It's a screenshot of text messages between myself and Tabor Vox. Tabor is assisting me in the boat crash case.
All right. Could you turn the screen to me real quick, please? All right, there's a reference here at the top. They damn sure aren't a placeholder or venue defendant, but they were hoping so. And then you respond about not walking, just taking $500K and not walking away from someone's judgment proof. Is that correct?
That's right.
And I'm sure the court is aware, but just very quickly, what's being said there about Alec not being just a placeholder or venue defendant?
Well, so there are a couple of things going on here. In October of 20, I filed a motion to compel. Alec said he was broke. He doesn't have any money. He may be able to cobble together some amount of money, but he's broke. And I didn't believe it. So I filed a motion to compel. And about a week after I'd filed that motion to compel, Danny Henderson, who again was Alec's personal lawyer, came to my partner, said he couldn't believe that we were going after Alec personally. It was a line in the sand that I'd crossed, a number of things like that. So that's what this conversation is about. And, you know, by November, this is, I think, November of 2020, the Beach family, they want accountability. They want a pound of flesh, and whatever that's going to be, it's only going to be through a jury or through a substantial settlement.
All right, well, let me back up and we'll get to the motion to compel in a second. You mentioned that you had been told by the defense essentially that Alec had no money, correct?
He's broke.
Right. Did they say he could cobble together a certain amount?
Thought he could cobble together $1 million.
$1 million. And did you believe that that was accurate?
It couldn't have been.
All right, and why did you not believe that that was accurate?
Well, when you practice law, not necessarily with, meaning in the same case, but when you go to a roster meeting, if there were 50 cases on the roster in Hampton, Alec may have had 50 or 60 of those percent of those cases. And so they're actively being settled. I know that he's actively making money, and you just can't possibly be broke if you're making money, not the way he was making money. And then beyond that, I mean, my clients have known Alec and his family forever. And so their perspective is that there's generational wealth as well.
Did you, was $1 million going to be enough money from your client's perspective to settle this case?
It wasn't enough from my perspective.
Okay.
I can explain that if you want.
Yes, please.
Yeah. So one of the things that I didn't appreciate, that I came to appreciate by this point in time is that, and it may not make a whole lot of sense, but if I told a lawyer who does what I do that I'd settled the case, there's a lot of speculation because I've had cases with the firm and members of the firm are my friends, that somehow there's a fix on. I think for a long time, Alec thought there was a fix on, that he was just a placeholder or a venue defendant.
Right.
And so if I told you I've settled the case, and then the next question would be, what did you settle it for? I said, well, I took the insurance company. If you knew what I know and what plaintiff's lawyers know, you'd think, well, there was a fix. The only reason I would take it is because there was a fix. I didn't see a substantial difference between that number and $1 million. And so I thought that if you told 10 lawyers who were knowledgeable about these kinds of matters, I took $1 million from Alec, who from everyone's perspective has lots of money, is making piles of money, they would think that it was a fix. So before we even get to what's a fair amount, what should you take? You know, the analogy I use with my clients is it's kind of like that show Deal or No Deal. You may have the $1 million suitcase or you may have a zero suitcase, but it's not until there's a significant enough offer that you could do worse that you should settle a case, any case. And so at $1 million, it just wasn't, there wasn't any risk to them that would prompt me to recommend them to take it.
Did you make any sort of formal or informal offer to them that involved the real property as well as any sort of payment plan?
When I was told that Alec was broke, I offered him a payment plan. Sometimes when you settle cases, medical malpractice cases, for instance, with the JUA, they will make payments. I offered for him to sign over Moselle and the beach house, open his books to see that he was broke, and then work out a payment plan on the balance.
So when you say, okay, you say he's broke, I don't believe that. Show me the books to prove that. What was your response from Alex's defense?
Well, it was sort of stonewalling to begin with. I mean, ultimately, I got a formal response, which was an objection that prompted the motion to compel in October of 2020.
Let me get this marked real quick. Show you what's been marked as States 402. See if you recognize this document.
Yeah. So this is my motion to compel, which attaches Alex's responses to the interrogatories and request for production.
All right. And when was this filed?
October 16th, 2020.
All right. All right, I'm going to put Exhibit B to this motion, your motion to compel, up on the screen and zoom it in a little bit. And in part, was this the objection to one of your supplemental interrogatories about what you're talking about opening the books?
Correct.
All right. And if you would, tell me what your interrogatory was asking for in number one, please.
Well, in as broad terms as
Well, let's just read it real quick if we could, please.
all
Can you
right.
read that?
List all checking and or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRAs maintained by you individually and or jointly with any others, or any other accounts over which you had signature authority in any capacity, regardless of whether or not the account or accounts have been closed from February 2019 to present.
All right. And ultimately, what was the Alex defense's response to that, generally? You don't have to read that, but just tell me.
It was overly broad, unduly burdensome, and irrelevant.
Okay. And so ultimately, you filed a motion to compel. Is that correct?
That's correct.
And the idea was, if you say you're broke, show me the books, and they had refused to with the response to this interrogatory, as well as others. Is that correct?
Correct.
All right. To your knowledge, when information was being gathered by the defendant in this particular case, let me ask you this, who were his attorneys in the boat case, Alex attorneys?
So his personal attorney, as I've said, was Danny Henderson, who is also a partner or shareholder with PMPED. Progressive had hired John Tiller, and John Tiller was a lawyer out of Charleston. He was mainly involved. At one point, there was Amy Bauer, who was an associate working with John Tiller, and then Elliot Condon ultimately. I think Amy left in February of 21, and by then I think Elliot Condon had been hired and was assisting John Tiller.
Okay. And Mr. Henderson is a partner in PMPED. It was also actively helping Alec or representing Alec in this case. Is that correct?
He was.
And he's the one that initially had brought you the insurance coverages for Alec to get you a chance to look at them and see what might be available, correct?
That's right.
As this motion to compel gets filed, what, if anything, happened with the sort of the communications between your side and the defense side as we moved into the months following the filing of that motion to compel? We already saw the one text. What else is going on as well?
Well, there's a lot of grumbling and sort of shock that I'm actually going to hold Alec personally responsible. Not so much with me, but like I mentioned, about a week after this, Danny Henderson contacts my partner. There were a number of times when Tabor Vox was contacted. And so nobody says anything directly to me in terms of that regard, but that's what's going on. It was said to them because they knew it would then be told to me.
When we look at the particular interrogatory right here that you have filed a motion to compel on, and what are you trying to get? What information are you trying to get with that interrogatory?
Well, you know, the way to, again, like I in my example of the deal or no deal, I mean, what I'm trying to do is put pressure. He doesn't want me to have access to his accounts. At the time, I think it's because I'll see how much money he actually is making and how much he has. And so, you know, that's what I'm trying to do is put pressure on him to force him into a settlement. You don't want it disclosed. Here are the keys to the jail. You enter into an agreement and let's go settle the case.
In the event, though, he doesn't settle in response to this, what information are you trying to get?
Well, it's certainly not a number. It's certainly not Alex's estimation of what his net value is. I wanted the accounts because I knew that the only way that he could be broke is that money had been hidden. And so I was going to look for and trace or begin that process of doing that.
All right, and explain that to the court. When you say that you knew that if he was, quote, broke, in your estimation, money had been hidden, and so therefore you were going to look for and trace that information. What do you mean by that? Why did you think money had been hidden?
Well, there wasn't any way he could be broke. I mean, I know he's actively settling cases. Some cases, big cases, some cases, small cases, but they stack up lots of cases. He's handling a lot of cases. So there's just no possibility that he could be broke by anyone's definition.
If ultimately, and we'll talk more about this in a minute, if ultimately you'd been successful in getting a list of the defendant's accounts, what would have been your next step once received?
Subpoenas.
Of those accounts?
To those institutions, yes.
Were you already aware that defendant had an account at the Bank of America?
I knew that he had a personal account with Bank of America. I knew he had an account with Palmetto State Bank. So I'm looking for the balance of accounts in terms of institutions and where else he had.
But you didn't know how many accounts or what those balances were or anything like that?
No, I had no idea. I knew he had multiple business entities. He had different LLCs. So I imagine there could be any combination of accounts out there, and some which would not have even been in his name.
After the motion to compel is filed, I'm going to show you what's been marked as States 4 or 3 and see if you recognize that document.
Yes.
Tell me what that is.
Again, it's a screenshot of text messages between Tabor Vox and myself.
All right. Put this up on the screen. if you would, got this up on the screen. So can you tell me what's going on? And again, this is in April of 2021. Is that correct?
It is.
And tell me what's going on with this conversation right here and how it relates to these issues.
Yeah. So in August of 20, I found out I had cancer. And by November, I knew how bad it was. And so in January, I went to, I had stage 4 cancer, and I went to Florida from the end of January till April the 15th on my first round of treatment. So I just come back. Shortly before I was diagnosed with cancer, John Tiller was also diagnosed with pancreatic cancer. And there's some degree of urgency between John Tiller and myself to finish this case. While I was in Florida, I think I failed to mention that Greg Parker's convenience store was also a defendant in the first case, but Greg Parker had done a number of things. And so before I leave, the issue is Greg Parker's moved to transfer venue to Beaufort County, which is where I had done the mock jury. The focus group was in Beaufort County. And while I'm in Florida, things have changed in terms of what he's done that have changed my perspective, because when I left, I intended to go to Beaufort. By the time I get back, I think I'm staying in Hampton. And so this conversation is, for the first time, I've said that I'm going to leave the case in Hampton. But if I think that Alec has fixed the jury, that he's done anything to affect the outcome of the trial, that I'm going to sue Paul and Maggie the next day in Beaufort.
Was that communicated to the defense?
Absolutely.
In the course of your investigation of this case, had you taken depositions of some of the officers who were involved in the investigation?
We did.
And at some point, was that some issues arose that were communicated to the state grand jury?
You're the one that tells me everything happens there is secret, so you tell me. But
I'm asking you today.
But yes.
Ultimately, and while you were in Florida in March and April of 2021, to your understanding, had the state grand jury reached out to you for information that you had uncovered in your investigation of the investigation into the boat crash?
Correct. And specifically the handling of the criminal investigation by law enforcement.
The investigation into the investigation.
Correct.
We'll show you what's been marked as states 404, 405, and 406. So you're for this hearing, and see if you recognize those, please. Generally.
I do.
All right. And tell me what's going on here, please.
There were a number of motions pending in the boat crash case. They had been pending for some time. I mentioned one a moment ago, a motion to transfer venue. There were some motions to amend. And so Judge Hall had set those motions to be heard. My recollection is May the 10th, 2021. So I'm back now. I got a couple weeks to sort of get my wits about what's going on and the motions are scheduled to be heard.
And that's May 11th, 2021?
It's either the 10th or my recollection is the 10th. I know the emails say something different, but, and in the week before, I don't know that John Tiller always knew how many chemotherapy treatments he was going to get or how long they were going to last until almost immediately before. So on or about May the 7th, John knew that the day of our hearing, his chemotherapy was going to run long and he wouldn't be done. And he had asked the judge to continue the motions, including the motion to compel.
All right. And looking at, again, we're now looking at Stage 405. What was the judge's initial response to Mr. Tiller's request to have that hearing continued based on his chemotherapy?
That we were going forward as scheduled, and that it says Mr. Condon, but it meant Miss Condon would be able to handle it.
All right, looking at Stage 406, what happened after that?
Ultimately, what happened is, my recollection is I sent another email to the judge expressing that I really didn't have, they were mainly my motions. Parker's had some motions, but that I didn't have a problem with continuing to accommodate Mr. Tiller. And the judge finally set a status conference for, maybe it was May the 11th.
All right. Just said that initially Judge Hall did not want to continue the May 2021 hearing, saying that there was another lawyer for Alex's side that can handle it, correct?
Correct.
And then you kind of interceded and said that this would work, and so it was rescheduled. Is that correct?
After a status conference.
After the status conference, it was rescheduled at that status conference?
It was rescheduled to June 10th.
June 10th? All right. I'm going to show you what's been marked as Stage 407 and Stage 408. And just quickly tell me if you generally recognize those documents.
I do. One is an email from John Tiller saying that the judge's law clerk said that the judge would be sending a message telling us that the hearing was going to be rescheduled to June 10th. The other is the email from the law clerk.
All right. So the hearing that was initially in May that Judge Hall did not want to reschedule was rescheduled for June 10th, 2021. Is that correct?
That is correct.
And ultimately, that would be to hear a number of things, but one of the most significant things would be your request for a list of all checking accounts from Alec, all identification of all accounts. Is that correct?
It is correct that motion was going to be heard.
And ultimately, when the murders happened, I'm going to show you what's been marked as Exhibit 408. What happened to that particular hearing that was scheduled that way?
It was continued.
All right. And is that what's reflected in this email right here?
It is.
And then Exhibit 407?
It is.
After the murders happened, let me ask you this. You've known Alec and have worked with him for a number of cases, is that correct?
I had not worked with Alec in a number of cases, but I've known him for a long time.
Okay, but you were generally familiar with him as a lawyer, is that right?
I was.
And what was your assessment of his skills as a plaintiff lawyer? What was he particularly good at?
He was particularly good at reading people, making people feel like they were the most important person in the room, and capitalizing on surprise with the defense. You have a case with Alec. He hasn't done anything. It's Monday morning of the roster. Maybe you expect it to be continued. And he says, I'm ready for trial. And so he leveraged a lot of settlements that way.
All right. Was he good at understanding the emotional and sympathetic aspects of plaintiff's work and tort work that can be so crucial in defining what recoveries can be in these types of cases?
Yeah, I think he was particularly good at reading people and knowing what made people tick.
You've testified that you had made it very clear to the defense throughout this time period that you were seeking a substantial personal recovery from Alec and had been told, well, he's broke, which you then responded, I don't believe that. Show me the books, correct?
Correct.
And that was what was on the table for June 10th, 2021, correct?
Among other things.
Among
Yes.
other things. But that's on the table, correct?
Correct.
After the murders happened, did that have any effect on your assessment of the case against Alec, and particularly as it relates to the sympathies and the emotion of the case, which can be so important to recovery?
Yes, it did.
Explain that to the court then.
Well, initially, probably say the first week, there was the shock and horror of what had happened. And nobody really thought about anything other than that. But pretty quickly, I recognized that the case against Alec, if he were a victim of some vigilante, would in fact be over.
Would be over.
It would be over.
And explain just quickly to the court why that's the case.
Well, when you're asking for a money judgment, people have to be motivated to give you that money judgment. If you represent Attila the Hun versus some sweet old grandmother, nobody's going to give Attila the Hun money. They would give money to some sweet grandmother. So if Alec had been victimized by a vigilante, nobody would have brought a verdict back against Alec. And I had other defendants in the case, so I would have ended the case against Alec.
You would have ended the case against Alec with just...
I probably, certainly there was $500,000 in insurance that was offered. I may have tried to see if he could cobble together the $1 million, but whatever the last offer would have been from Alec's side, that would have been the offer that we took.
You had mentioned before that you had advised the defense of some of the mock jury presentations that you had done and some of the results from that and how they were very favorable to your case. Is that correct?
The defense and some of Alec's partners, yes.
And it's fair to say, though, that as you just stated, that if Alec had been the victim of some sort of vigilante, those sympathies would have entirely changed as it related to Alec and Paul as well. Is that correct?
Certainly.
And that's led to what your assessment then in the wake of these murders. Is that correct?
Correct.
At some point, did you receive any call or any communication from the Satterfields about any recovery in the Gloria Satterfield death?
At some point, my recollection is it's early September of 21. Eric Harriet came to my office about that. There are a number of articles in the paper or the papers that are talking about this previous wrongful death case and wrongful death settlement. And he came to my office at that time.
All right. And did you send them to someone?
I sent him to Eric Bland.
Hold on for me 1 second. Nothing further this time, Your Honor.
By the defense.
Good morning, Mr. Tinsel.
How are you?
You testified at length to the state grand jury, basically this similar testimony you're giving here today. Is that correct?
The testimony I gave today is included in what I said to the state grand jury, yes.
And it seems like the gist of this is that you were suing Alex Murdaugh, who you believed was underinsured for this incident, and you're going to go after his personal assets, and that was going to put some financial pressure on him. Is that correct?
Probably not exactly. I mean, I don't mean to quibble with you over the words you used, but I don't think it was financial pressure because I was holding him personally accountable. I was insisting that he pay. I didn't see how a payment plan on a settlement would put any pressure on Alec. It was sort of a deal that he couldn't turn down from where I sat.
But you were asking for money from him.
Sure.
Yeah. And the inquiry here today is about money, his finances, correct?
I don't think so, but it certainly concerns his money.
And you're anticipating you're going to go to trial, is that correct?
Yes.
You're going to go to trial and get a verdict against Alex Murdaugh, correct? That was what you thought. That's where this was going.
No, I mean, I didn't see how any reasonable person wouldn't settle the case, especially Alec. So I expected the case to settle. 90% of cases settle, maybe 99. But if we had to try it, yes, we were going to try it.
And if he were unable to offer more money, then your expectation on, say, on June 7th, before these murders, your expectation was if he doesn't offer more money, we're going to trial.
Any money.
Right.
It was no money.
Right.
No money had been offered.
So your expectation then was we're going to trial.
If you offer me no money in a case that I'm pursuing against you, then the response is we are going to trial.
And you were pretty far from trial on June 7th, 2021, were you not?
No.
You believe you were close to taking it to trial?
There was an urgency because John Tiller knew that he had about a year to live. And we were going to try that case. My expectation was early fall, late summer.
You expected to try the boat case in the summer of 2020, late summer of 2021?
August, September, October, sometime in that time.
You felt like you were only 2 or 3 months away from trial?
Sure.
Even though we had all these pending motions that hadn't even been heard, including what venue to have?
I had tried the case 2 times with a Beaufort jury during COVID. I was ready to go to trial.
On that day, on June 7th, you hadn't even yet asserted a negligent entrustment claim against Alex, had you?
Well, I had with John Tiller. John Tiller knew and had agreed to the amendment.
Right.
There were a number of things that Alex counsel had agreed to, including knowing that there was substantial punitive evidence in the case.
But you, at that time, you hadn't even asserted that claim to the court. That wasn't before the court, was it? That was just a conversation with John Tiller.
That's the conversation that mattered, because John Tiller would be the one who would object to the late presentation of the evidence, the late presentation of an expert, and he had agreed to all those things.
But he had objected to the financial discovery you asked for.
Well, there was an objection posed, correct?
But he did object to that.
When that answer was given in October or September of 20, it was an objection.
And the hearing that motion to compel the financial detail, the testimonies, that's just one of many motions that needed to be heard. Is that correct?
Correct.
There are many motions that had piled up and needed to be heard.
There were several.
There were several. Do you remember what they all were?
There was a motion to change venue. There was a motion to compel against Parker's. There was, Parker's had one or two motions. Some of the motions got resolved, one of which was this motion to assert admiralty in the case, and with the agreement that I would amend to assert your negligent entrustment claim, to get in all of the evidence that they knew I had. That was resolved that way.
And you've had a lot of motions practice in this case with Parker's, haven't you?
More so since the murder.
But has that motions practice with Parker's been about the murders of Maggie and Paul?
Well, I mean, it's about it in the sense that that it certainly created a lot of additional issues to deal with, but not specifically.
There was a lot of motion practice about allegations of leaking of video from mediation, for example, correct?
I don't know about a lot, but I had filed a motion that I ultimately withdrew.
And you believe that you were going to drag Parker's to a trial within 2 or 3 months, late summer of June 7th, even though we have all these fairly preliminary motions that haven't been heard, change of venue, asking amend pleadings, motions to compel discovery.
Yeah, maybe you've never tried a civil case. So when COVID happened and everything was shut down for 2 months, I got my case together. My case is not dependent on, if I'm forced to try it, the bank institutions where he has accounts. My case is not dependent on the leaked video. That's a separate matter, and ended up being a separate lawsuit. So the answer is yes. I was ready to try my case.
And you didn't need, for example, an answer on the motion to compel that was pending against Parker's. You didn't actually need any of that stuff to go to trial against Parker's. Is that what you're saying?
You're talking about the percentage of financials, percentage of sales that alcohol made up in his profits? No, I didn't need that.
Well, let's put that up.
I wanted it, but I didn't need it.
Show you what's been marked as Defendant's Exhibit 82. You recognize that?
It appears to be my motion to compel against Greg Parker's company.
We pull up 82, please. And this is the document on the screen that I've handed to you. So we have, it's not just buried in here is some request for financial information, but you're requesting answers to request for production 3, request for production 11, request for production 16, request for production 17, which is financial information, request for production 18, request for production 19, request for production 20, request for production 22, request interrogatory number 5, interrogatory number 8, interrogatory number 9, interrogatory number 10, interrogatory number 12, interrogatory number 13, interrogatory number 15, interrogatory number 18. It seems like it's quite a bit of discovery you're demanding from Parker's in this motion.
Which I would have had the answer to on June 10th.
So you didn't-
Either I was getting it or I wasn't getting it, but my case wasn't dependent on these things. They may have helped my case. They may have put pressure on Parker's camp like I was trying to put pressure on Alex, but the trial wasn't dependent on these things.
And turning to the motion to compel Alex, first, do you believe that the Judge Hall's initial request in May to go forward with pending motion hearings was telegraphing a ruling on that specific motion, or do you believe that that was him looking at these motions piling up and wanting to get some movement?
Yeah, I think so. There's nobody in the courtroom, maybe even including me, that wants the case resolved more than Judge Hall.
And when the late Mr. Tiller asked for a continuance, you don't believe that was any kind of stalling tactic, do you?
No.
That was a legitimate health-based concern.
And if you read my emails, you would see that I immediately agreed to it. John Tiller was my friend.
With regards to what you're asking for from Alex, let's maybe pull that up. I believe the state has already marked this as an exhibit, but this is the motion to compel. Can we pull up 80, please? It's already been shown to you, but I'll show you when it's been marked as 80 for your reference. So this is asking for an order compelling production on interrogatories 9 and 10, and then a set of supplemental interrogatories and supplemental requests for production. Is that correct?
It is.
And if we turn to
And 9 and 10 are important as well. We didn't cover that, but I'm happy to speak to 9 and 10 because, 9 and 10 asked Alec about.
Sir, no one's asked you about it.
Okay.
And we'll get to it, but first let's turn to answers to the first supplemental interrogatories. This is the first page of Exhibit B. So we can see what it is that is being asked for.
There's no D in mine, I'm sorry.
B.
Oh,
Exhibit
B?
B. It's the first page of what's Exhibit B in here. It's right there, that's it. It's the first page after the motion, so it'd be page 9 of the PDF.
They're not
So
numbered, but
Mr. Waters asked you about this list of all checking, savings accounts, retirement accounts, and then you don't have to highlight or expand this stuff. All stock, and then number 2, all stock certificates, and we go to the next page. All property interest of property of every kind whatsoever, from February 24, 2019 forward. All life insurance policies, 4 or 5, all personal financial statements submitted to any bank, et cetera. Profit sharing plans, pension plans, et cetera. Doesn't this look like supplemental discovery after you get a judgment? Supplemental proceedings?
I never had been involved in supplemental proceedings, so no, I don't think so. This is what my people needed answers to before they would agree to take anything that Alec would have offered.
In tort cases against individuals, in this case, a negligence in entrusting a boat and then an alcohol-related incident, before there's even motions for summary judgment, before there's any consideration of whether a case has been made for punitive damages, do you typically get this level of financial discovery of defendants?
I think so. I think the judge ultimately agreed to give it to him.
He agreed to give it to you.
Sure.
But I thought the hearing didn't happen.
Well, you thought wrong. There's a lot of papers, so maybe you got confused.
He granted this motion?
I think so. You want to see the order?
Yeah.
It's the record, October 7th, 2021.
And correct me if I'm wrong, what you've highlighted here is that Mr. Tiller, because of circumstances beyond his control, unable to gather, provide necessary information, answer requested interrogatories. Once the information is made available to Attorney Tiller, the court will schedule a hearing.
If necessary. You forgot the last part.
If necessary. The
Yes.
court will schedule a hearing
That's
if
right.
necessary.
Which
If
means,
Mr. Tiller, the attorney on the case, can from his own client get the information. This is no way says that the court granted this motion, does it, sir?
only to you, I think. I mean, it's clear that John said that Alec was unavailable because he was in rehab at the time. He couldn't get the material. He's going to get the material, and the judge ordered, you get the material, and if we need to schedule a hearing because you don't have the answers that you want, Mr. Tinsley, then we'll reschedule the hearing.
This is an order that says the court will schedule a hearing on this. Granted?
Yeah, I think that's what it says. As a practical matter, when parties have discovery motions, oftentimes, like Alex has, in his own statement, said he was working on getting the answers. The reason is you give the answers because you don't want to face what could happen in the argument with the judge. So my point is that if the judge were going to say it's premature, you're not going to get it, it's denied, any of the things you suggested in your motion, he would have said that. That's not what he did. That's not what happened.
This is visible. I just want to get the date that this order is, which is October 6, 2021. You asked for financial information in the motion that was pending against Parker's that was also going to be heard on June 10th.
It was different and for different reasons.
You asked for alcohol sales, correct?
What I explained to Judge Hall is that they say he's broke. And before
No, sir, I'm asking what you asked for from Parker's. I'm pretty sure that wasn't, they say he's broke. What were you asking for from Parker's?
I asked for, among other things, the percent of alcohol sales that made up his net profit, I believe.
And this was like a dram shop action against Parker's, correct? They sold the alcohol.
Like a dram shop action, yes.
Okay. And did you get a ruling on that? That request for that financial information from Parker's that was going to be heard on that June 10th date, just along with all these other motions that had piled up in a case that apparently wasn't moving very quickly.
I understand you don't want to acknowledge what I've handed you, but
Sir, I asked you what the ruling was on the motion from Parker's.
It was very limited, and as it related to the percent of sales of alcohol that made up his profit, it was premature. The judge ruled, unlike he did in that order I handed you, that it was premature at the time.
Why was it premature?
Well, the difference between Parker's and Alex is that Alex had, and his lawyers had, 25 videos of alcohol. They had the punitive damages evidence. You didn't see that with Parker's. It was just a straight up transaction and sale. So to the extent you're suggesting that there wasn't this evidence, there were these mere allegations of negligent parenting, that wasn't the case. That wasn't the argument.
You presented that evidence to the court?
I didn't have to present it to the court. That's what you don't understand. John Tiller knew about it. John Tiller is the one who's responding because John Tiller knows ultimately he's going to be in front of the judge.
So you're saying the court was granting your motion, though obviously it was saying there might be a hearing on the motion, and maybe at that hearing you would present some evidence in support. But
I don't think that's what it says.
I mean, you asked for financial information from Parker's. It was deemed premature because it related to punitive damages, correct?
It was different than the motion that related to Alex.
Because the law is how much money you have is a factor for punitive damages, correct?
Well, you're making statements of law. I'm telling you what was happening, and what was happening is that Alex's lawyers knew what the evidence was. They knew what the amendment was going to be and the allegations, and he knew ultimately he was going to be back in front of Judge Hall making some ridiculous argument that you're suggesting now.
And again, the gist of this is that there was perhaps going to be this judgment day, I think is a term the state has used, but that was going to be trial, right? That was going to be the verdict. That was going to be judgment day, not this motion hearing where there's a pile of motions that have piled up. And we saw the one that asked for financial information was deemed premature.
Not at all. You know what was going on is, as I've said a number of times, Danny Henderson was very involved. Danny Henderson was a shareholder. before I would have gotten the bank account information, before I would have seen the records, Danny Henderson would have seen those records. And I've seen the records. I've seen all the bank statements now. It would have been apparent to Danny Henderson, and I believe it would have been apparent to me what Alec had been doing. So that's the judgment day, is the discovery. And there were a lot of threads that were being pulled, and it was subject to unraveling at any moment. And if those records were disclosed, if Danny Henderson reviewed those records, he would have known there's no way Alec's getting these checks. There's no way these checks are going to Forge. There's no way that this money should be transferred.
And even if, hypothetically, had this hearing on the 10th, and you got a different ruling regarding Alex Murdaugh than you got against Parker's, but for some reason it's not premature to him, isn't it true all you would have been all you could have gotten would have been a net worth statement, financial statement?
Not even remotely close.
Isn't that you don't, in your opinion, there's no case law out there saying that's what you get, that's the measure for punitive damages, net worth. There's no such case in your opinion as an attorney.
I had 7 circuit court orders where the circuit court had ruled that you don't bifurcate discovery, that it wouldn't be proper to have denied the motion, and then what are we going to do? We're going to try the case, and suddenly we're going to stop the trial and go and do the discovery? No. And so I had 7 circuit court orders that I handed up to Judge Hall that supported our position. I think that that's what Judge Hall did in his order. And again, the issue is not that complicated. It's, does he have the ability to pay? Is he broke such that these people should accept this pitiful offer if he could cobble it together?
But sir, that's not what you get on a motion to compel, is it? Right. You just said ability to pay so your client can make a decision on whether to accept a settlement offer, but that is not what the motion to compel is about, is it? It's about evidence for trial. That's the legal standard, is it not?
No, the motion to compel was about putting pressure on Alec. I didn't really give 2 cents about whether or not he ultimately had money, because I knew he had money. I didn't need those things. The fact that he didn't want me to have them is the reason that I'm pushing it.
So,
I just didn't know why he didn't want me to have them at the time. I do now.
So the motion to compel was to put pressure on Alex. It wasn't about an expectation the judge was actually going to give you this stuff on June 10th?
If you're a good plaintiff's lawyer, everything you do in a case is to put pressure on the other side.
But the expectation of the outcome of a hearing on June 10th was not that you're going to get to launch a full-scale forensic audit because you had a conversation with someone whose lawyer said, oh, he's broke, and you didn't believe it. Not at that stage of the litigation, sir, is it? That's not what's going to happen, is it?
I don't think you need a full-scale forensic audit for something a 5-year-old could see. So, no.
You wanted pretrial ability to pay discovery to inform whether or not to accept compulsive discovery, compelled, so that your client could decide whether or not to take a settlement offer.
I know you don't like the answer, but I'm telling you, I did not care about the answer. What I cared about was putting pressure on Alec. I think that your assessment of the law is wrong, and I didn't really care whether I got it at the end of the day. I knew he didn't want me to have it. And so that's what I was doing, was putting pressure on him. Would have suited me fine not to have ever gotten anything and to leverage it into a settlement and gone on about my way. But that's not what happened.
So the motion was not about obtaining information that may have been relevant at trial. It was about getting information to inform whether or not your client would take a settlement offer.
What I told Judge Hall was, they say he's broke. My people have lived in Hampton their entire lives. They do not believe he's broke. If he's broke, we need to open the books and let them see it so that they can then form an informed opinion about what they should do. It didn't have anything to do with the trial. It had to do with the case and resolving the case.
And then I think we briefly touched on Satterfield. Just to be clear, they came to you, the first time they came into your office was September 21?
It's either late August or early September, but very early September. And since now I'm thinking that since the roadside shooting, whatever that ridiculousness was the 4th, it could have been August.
Okay. But it was well after June 7th.
It was after June 7th.
Thank you, court's indulgence. If the hearing had gone forward on June 10th, this was a Thursday, what outcome did you expect?
The same one that we got when it went forward. The judge hadn't seen.
Well, I mean, the outcome wouldn't have been the court will schedule a hearing. I mean, if the hearing had gone forward, what outcome do you would you have expected?
Well, now I know that Alec was working on Monday to get the information together. If the objection was sufficient, there's no reason he would be getting the information together on Monday. So I could have gotten the information. But since that didn't happen, if we had argued it, I think I would have had the same outcome. Because he didn't.
Let me just make it a little simpler. Would the court have issued an order? Right? Some order would have issued on the motion.
I would expect an order to issue.
Break it down. An order would have issued at some point later, and what, if it were granting your motion, what would that order say?
I think it would say the same thing as.
Well, sir, that says a motion hearing will be scheduled if necessary. It obviously wouldn't say that. So what would the order granting the motion say?
Look, again, what it says is that once Mr. Tiller gets the information from Alec, gives it to me, if necessary, if I deem it insufficient, then we'll have another hearing and we'll argue about it. So that's what I expect.
Voluntary disclosure, and then if you deem that insufficient, we go have a motion to compel hearing?
That's the way motions to compel go every single day.
So if you deemed it insufficient, if the court actually had to issue an order on your motion, what you would have gotten you've gotten his, would the law firm books have been open to you?
I don't know that I'm asking for the law firm books. I'm asking for Alex.
Right. Would you have gotten, what, a financial statement?
No.
The court would have ordered every account detailed listed to you, all his personal accounts? Just because you asked for it to inform a settlement decision?
I was asking for the names of the institutions where he had accounts. I told you that.
Right, to subpoena.
Sure. But
And
that's different.
that
than
would have
giving
been
me-
resisted, and there would have been further litigation. This process would have taken some time, would it, if it was resisted, right?
I'm not sure if what was resisted.
If you got the names of the banks and issued subpoenas, there would be motions to quash the subpoenas.
Well, you're
Right.
speculating the same as you're asking me to speculate. I'm trying to talk to you about what the judge actually did and what was actually in front of the judge. I get you don't want to talk about that, but and we can speculate any number of things could have happened.
That at some point in the future, you would maybe get a voluntary disclosure, and if you didn't like it, then the motion would be heard, the motion to compel. That's what you say it says, right?
Well, if we had shown up and they had made the argument that you're advancing here, then maybe in this imaginary world, there's things that didn't happen, the judge would have actually ruled on it. We would have a ruling on whether or not it was relevant, whether or not I was entitled to it.
And you'd have been relevant for Alex, but not for Parker's.
You gotta appreciate that.
Look, there are different things that are being asked here. And to your point, if it were the same, why didn't the judge sign the same order that you say he would have done? That's not what he did. At the same time we argued the Parker's motion, we argued the motion for Alec. And so he came to two different conclusions on those issues. One is he said it's premature. The other is that Mr. Tiller's going to get the information give it to the plaintiffs, and if it's not sufficient, we'll have another hearing. I don't know how you can be any clearer than that.
Can you guys hear me okay on the microphone? Or can you hear me at all? Just want to make sure that we got our audio here is up and running. We've got the courtroom is super loud. That's all I'm saying. Nice. All right. Good deal. Good to see everybody in here today. I appreciate you guys jumping in. If you would share the stream out, I'd really appreciate it. This is definitely an interesting trial, and it's getting saucy, man. This guy is great. I loved when he said, nobody tells me what to do. Like, he just laid it out there. He's like, nah, I know what I'm doing, and you guys are trash. He said, we have that order. Where is it? Well, let me show you, man. It's right here. I highlighted it for you so you could read it.
So just, and maybe we can agree on this.
Oh, yeah, they said go in on him, but
The hearing had gone
it's
forward.
not going for him the way he wanted it to go.
That day would not have been some sort of judgment day when everything unravels, correct? There would have been further activity, maybe a voluntary disclosure, an analysis by you whether it's adequate, another hearing if you thought it wasn't, maybe some subpoenas would go out. There was going to be some time
My volume as well?
after that.
Is that better?
Is that fair?
I think it's fair to say that there wouldn't have been an explosion on June the 10th, but the fuse was lit the moment that information became available in the case. Not as much to me, but certainly to
Hopefully this
Danny
is better.
Henderson, who would have, like the phone records, like some of the other materials, reviewed it before I got it. And Alec would have known that.
I mean, in that analogy, aren't you really saying that the fuse was lit when you were going after his assets, and that fuse is going to go down until trial because you're going to go to trial against him, and that's when the fuse would burn down?
I think the fuse was lit when he started stealing money.
Yeah. So it wasn't going to be lit on June 10th.
They're certainly getting a lot more oxygen.
But it was lit way before, and it was going to keep burning well after June 10th.
I don't know about well after, but it wouldn't have been Judgment Day on June the 10th, but he would have known it was beginning to unravel.
Not Judgment Day. Well, yeah. No further questions, John.
Yes, sir.
And that's really the point, isn't it, though, that had that hearing taken place on June 10th, 2021, it could potentially set in motion, or was going to set in motion, a process that ultimately would not have ended until there was either settlement or disclosure of that information, correct?
I believe so.
And so just the fact of that hearing taking place, and whether it's an order or representations by the defense or whatever it is, that process, if it occurs, starts and it has an inevitable conclusion, correct?
Objection. Your Honor.
There's only one.
Objection, Your Honor. Lead.
No, lead the witness.
If the hearing takes place on June 10th, 2021, what is the net effect of what could happen at that point?
The discovery of everything he's done.
Whether it happens that day or some point in time.
Correct.
You had filed this motion to compel, or had you filed this motion to compel because you had been advised supposedly that Alec was broke and you didn't believe it?
Exclusively for that reason.
And you believed that if he was broke, he had to be hiding assets?
And if he were hiding assets, he didn't want me to discover it, which would be the pressure point.
That's why they hide him, so you won't discover him. Played hide and go seek once or twice.
Were you merely asking for a financial declaration at this June 10th, 21 hearing?
No, I was, it's broader than that, but I wanted the institutions because I knew I couldn't trust the number I would have gotten
From Alec.
from him.
You were asked a little bit about having not pled certain theories yet at this point in time, such as negligent entrustment. Can you explain a little bit about why that was, if that was still out there?
It was only out there in the sense of the pleadings that were on file. I mean, John Tiller had already agreed to the amendment. It was already coming. I had shown him the videos a long time before that, of alcohol, the Facebook, social media likes of Paul consuming alcohol, having alcohol.
If you didn't know, look at the next little fact I'm going to put up here.
Only
for
on
you
the
guys
documents that were filed.
to add to this one that's on there right now about the
Were
8.7
those issues
that
though
he's
in play in your conversations with the defense?
a mysterious death.
Were
on
those
this
issues already in play in your conversations with the defense?
I'm not quite following you. Which issues?
Additional theories of liability that might not have been filed.
Oh, absolutely. No, I mean, those were, all I'm saying is that the black ink wasn't on the white paper, but John Tiller knew we had discussed, these are the issues.
I'm gonna hand this back to you, but I'd show you what's been marked as States 407, so you can recognize that.
Wow.
Yes, this is the order that I handed, whatever that lawyer's name was.
Mr.
Mind you,
Barber?
that was a mysterious death of the housekeeper. There was a mysterious death there. They didn't know why or what, how. They said she tripped and fell down some steps, apparently, that the dogs knocked her down. But it was the mom and the son that were there
That's from
that made
October
the
of
call.
2021, is that correct?
And again, there was
Yes.
a lot of mystery around that death. So, like all the deaths that happened out in that area that involved the Murdaugh family, like these guys
You had
are no stranger
previously
to cover ups. We'll put it like that.
testified that $1 million, was not going to be enough, at least prior to the murders. Is that correct?
Correct.
Had you come up with a number that had been conveyed that was far, far in excess of that?
A demand to Alec?
Yes.
Yes.
And that also included signing over Moselle and Edisto,
It was an option.
as well as a payment plan?
Payment plan was an option. I mean, it was, you could pay this amount, you can sign over these properties, work out a payment plan on the balance. I didn't care how we got it done. It was just a matter of him doing it.
Was the payment plan an option because you believe that he still would have a lucrative law practice from which he could generate money to pay your clients?
Yes.
Thank you, Your Honor. Nothing further.
Anything further?
Nothing, Your Honor.
Thank you.
Thank you, Your Honor.
Step down. Next witness.
Your Honor, a couple things. Our next witness would be Ronnie Crosby. Just to let the court know, the court indicated Friday that we had kind of already established, as far as clear and convincing evidence on the law firm issues. Mr. Crosby would be here about that meeting I referenced to, Your Honor, just to establish the circumstances of that. I don't plan at this time to get into testimony that he may offer about the circumstances of the fake forge and all of that, based on Your Honor saying that you had heard sufficient evidence regarding that. So I just wanted to make sure that was acceptable to the
Sorry, I was
court.
muted.
I did want to cross
So
the
I'm
bridge
trying to
though, of
understand
this,
better while he's asking this.
meeting on June the 10th as to the circumstances of it. Again,
What is going on
that's
with
that
the
there was no,
representation of
attorney-client
witnesses without the jury?
privilege
That's
to
what
that
I'm
because
curious
of the
about.
presence of third parties, then at that time, we don't have to do it on the stand, but I would, make myself, in prep in the evening or whatever, privy to that particular conversation.
The other comment about the attorney-client privilege issue, Mr. Griffin.
Your Honor, I'm still at a loss as to what he's attempting to accomplish through this.
He wants to call
Right.
some of the folks as witnesses who were there when you were there, along with Mr. Murdaugh.
And so it is the
In the
question,
courtroom, John?
these witnesses are going to testify as to what Alec and I were talking about, because we've had attorney-client privilege conversations every day in this courtroom, and there are 250 people in this room. Does that mean that the conversations are not privileged? I don't think so. And so it really is more nuanced than is someone else in the room. And I don't know if they overheard anything that I talked to Mr. Murdaugh about, and that's where this is going. Or if the question is Mr. Murdaugh talking to Mr. Crosby, and is that privilege? Or Mr. Murdaugh talking to to Mr. Lee Coke, and was that privileged? I'm at a loss here.
I don't know either, but I say as far as the law is concerned that Mr. Griffin was not the lawyer for Mr. Crosby or any other party. Mr. Griffin was solely the lawyer for Mr. Murdaugh. So there is no attorney-client privilege involving people that Mr. Griffin does not represent.
Sure, and I guess what I'm actually trying out of an abundance of caution to protect his attorney-client privilege. I mean, Mr. Griffin says he's at a loss when I've been bending over backwards to make sure I'm not privy to something that Your Honor might find productive.
I don't know what you're seeking. There is no attorney-client privilege.
So while they're
involving
talking, I just
people
want to make sure we got our
Griffin
levels right.
does
You
not
guys hear me
represent.
okay?
If you have
And
them
how
as
is the sound in the
witnesses,
courtroom? Is that
call
loud
them
enough?
as witnesses. If there are necessary
John, you
witnesses
son of
for
a gun.
hearing, you may proceed.
So are we good here on the
You wanna call
volume
Ronnie
levels
Crosby to the stand?
between the courtroom and my volume? And I'm going to try to do a lot less talking while the witnesses are on the stand. I know I got a lot of feedback, a couple thousand comments in the and I'm still getting them over the Darrell Brooks trial, where people were asking me to not talk. But again, a lot of that was because I had personal information and things that I found were pertinent to the case that I wanted to talk about. And we're going to be doing that again through this case. But I'm going to try to post more comments and post more tags that you'll see on screen that'll help you better navigate some of the things that I'm saying without having to not navigate it for you, without having to narrate a lot of it. So I believe the jury is entering the room now. I think they said 11 o'clock Eastern Standard. The jury was going to be coming in. So now we've got, it's 11:07 over there. Jury should be coming into the room right now. If you guys would, please share the stream out. This trial is going to keep going. It's going to have a lot of interesting twists, a lot of interesting turns. And again, this has been made into an HBO. There's several documentaries about this actually that are ongoing. That if you want to catch some really deep look at this case, it's incredibly interesting. All of the things that have surrounded this trial, not just this trial, but this family, the Murdaugh family, this dynasty, if you call it, like that has had a young homosexual man that was killed, that was tied to relationships that he was having with one of the Murdaugh boys, found dead in an odd way in the street. The housekeeper, all these financial crimes, and the way that they've been able to slide through all this without any kind of
Ronnie Crosby, Crosby, Crosby.
Ronnie Crosby.
I'm okay.
Or tell the court what your profession is and where you work.
I am an attorney that practicing law with the Parker Law Group.
And are you a former law partner of the defendant, Alex Murdaugh?
I am.
You see him in the courtroom here?
I do.
Where is he sitting?
He is sitting between Mr. Griffin and Mr. Harpootlian at the defense table.
Definitely worth checking out.
And again, this is an in-camera hearing, so you understand I'm not exploring everything that might, depending on the judge's ruling, be before a jury. But I do want to explore a particular meeting. Were you present for a meeting in which the defendant spoke on June 10th, 2021?
I was.
And at this particular meeting, can you tell the court who all was present?
I'm not going to swear that I don't miss somebody because it was a fluid event. My recollection is it would have been late morning, midday that we gathered at Alex's brother John Marvin's place, which is not very far from Alameda that I've been talking about. And I know I'd been by to see Mr. Randolph that morning. There was going to be a meeting with law enforcement. They had given Alec a couple of days before they were meeting with him. And so we gathered there. I was present. Mark Ball was present. Lee Cope was present. John Marvin was present. At some point, I believe, I don't remember exactly when Buster arrived. Jim Griffin arrived at some point. And I want to say Corey Fleming was there. And there could have been others.
All right. While that group of people were assembled, did the defendant, and I don't want to get into the content, but the defendant make any statements about what had happened on the night of June 7th, 2021?
He did. We were there as friends. We had been with him starting the night of the murders every day. And we were there for support, and he went over the events of that afternoon or that evening, starting from the time he got home from work until the discovery of Paul and Maggie.
Where was this discussion taking place? Was it inside, outside?
We were in John's house there. I guess, I don't know if he calls it a house or a hunting lodge, but we were inside. But largely, I mean, there was some in and out of the house as well, but the majority, we were all sitting in a room together, and I was doing more listening than talking.
And were these the statements being made by the defendant? Were they being made quietly to his counsel, or were they being made openly to all the people in the room?
Well, the statements that I heard obviously were being, for me to hear them, I was not overhearing a conversation that was private between Mr. Griffin and Mr. Murdaugh. They did have some private conversations that the rest of us were not privy to, but so there's a mixture of that.
But there were private conversations that you don't know what they were because you weren't privy to those, correct?
Correct. And this was before, I believe, the South Carolina Law Enforcement Division agents arrived at this location.
To be clear for the court, you did at other times, aside from this meeting or this discussion, have conversations with Alec about his activities the night of June 7th, 2021. They were outside of this, is that correct?
Well, that's correct. I mean, obviously, we all were in shock, but also wanted to try to find out what all had went on, because we, as we got past that night of June 7th and the morning of June 8th, we're all, trying to help find out what had happened and who may have been a potential suspect.
But in this investigation and in preparation, you were instructed to stay away from those until from that meeting, as opposed to the other ones that weren't in that meeting, out of an abundance of caution until we could get guidance from the court as to whether or not those in any way were protected. Is that correct?
That's correct. I mean, we had multiple conversations, as you might expect, all of us in a group, and it may be pieces and parts. But what you and I have discussed up until now have been outside of what was discussed on June 10th at John Marvin's house.
Okay. Your Honor, I don't believe I have anything further for purposes of this matter.
Anything further?
Yeah. Please, court. Crosby, I believe Danny Henderson was also there.
Yeah, I told you I might miss one, but Danny was there. I don't think Danny was there at first, but he ultimately arrived.
And the meeting had been scheduled so that Alec and others, Brother Randy, for one, and John Marvin and Buster, could be interviewed by SLED. Is that correct?
That's correct. The purpose was that SLED had scheduled a time, and I don't know who scheduled it with, and you're correct, Randy was there. And it was essentially going over the timeline of the evening of the 7th, because knowing that Alec was going to be interviewed, and I think Buster was, and maybe Randy and John Marvin over the course of that afternoon.
And you were not scheduled to be interviewed, correct?
I was not scheduled to be interviewed. And Jim, now that you speak of it, I do think that while Mr. Randolph did not come into the meeting, he and whoever brought him over did come by. Right. To the tube that I'd forgotten.
Yeah, and
then went back to Alameda,
where he died within hours of that. Right?
he died as we were leaving, or right after we left this meeting with law enforcement. We were on our way back to, and Randy got a call.
Did you sit in any of the interviews conducted by SLED in the car?
I did not.
And Lee Cope was there, and he was not to be interviewed, right? That's not why he was present.
We were there as friends to provide support and listen.
And Mark Ball also is present.
Mark was, and I know Mark had some meetings with law enforcement about some concerns that he had, not, about potential suspects and safety of.
And had you recall whether you and or Mark and Lee had given Alex some advice about whether he needed to have a lawyer at this interview?
I don't remember that specifically, but knowing that you were already involved, I mean, any of us would have thought it was a good idea.
Okay. What do you know whether Alec considered you and Mark and Lee, as well as Danny and Corey, as his counsel that day? I mean, do you know what he was thinking?
I don't know what he was thinking, but he never approached me as his lawyer, or throughout this, I never had the perception that I was representing him.
Well, did you or in your presence, Mark Ball or Lee Cope, make it clear to Alec that, hey, we're not your lawyers here, and if you talk to Jim Griffin in my presence, then there goes the attorney-client privilege? Did you give him that warning?
Mr. Griffin, we're all lawyers. I don't, other than John and Buster that were there, I don't think anybody needed to say that. And it never crossed my mind that when we were sitting in a room and all of us were talking, that we were somehow representing Alec.
No, I understand that. And it's okay.
And nor would I ever do that, because I don't practice in the area that you do.
Right. But it's clear that Danny had an ongoing attorney-client relationship with Alec. Is that right?
He did. With regard to the boating accident, he was Alec's personal counsel in that.
And Danny had sat in the initial interview that was conducted by SLED Agent Owen and Colleton County Deputy Laura Rutland on the night of June the 7th. Are you aware of that?
Yes, I was aware of that.
Okay. And he was representing Alec during that interview, as far as you know.
I don't know. I saw, I mean, I know when Alec got in the car, we felt like one of us ought to sit in there with him, for support, because.
Well, can you say for certain that whenever you heard conversations from Alec about his recollection of what happened on the 7th, that there were any non-lawyers in the room? And I guess non-lawyers have been Buster and John Marvin. I mean, can you say for certain there were no non-lawyers in the room?
There were.
That you're referring to hearing conversations with Alec in the group about what happened on the events of the evening of June the 7th. And my question to you is, when Alec was making these statements, let me make it clear, were there just lawyers in the room?
I can tell you that John and Buster were there for points of time. Can I tell you who was sitting and where John had walked out when I heard any specific thing? I can't tell you that. I couldn't catalog because I said it's a little bit fluid. People come and go, and law enforcement arriving outside and people walking out to greet them. I mean, it wasn't like the SLED agents just showed up and it was some rigid thing where you walked out. I mean, there was small talk going on with the officers as well.
Sure. Okay. 1 second, Your Honor, please. That's all the questions I have, Your Honor.
Nothing further, Your Honor.
Thank you. This issue.
This particular issue, no, I know that's a little bit different than the larger issue we've been dealing with, and I'll certainly be happy to argue that further if the court would like. As far as the larger issues, one of the things that we, in discussions with the defense, that we've stayed away from so far in testimony is the side of the road. And that might be the other piece of the puzzle a little bit that might need some in-camera testimony as I think all of this through. I know that we're butting up with the jury being here shortly, but
That can be done at a later time.
yes, sir.
That's my mistake. I thought the jury was already in the courtroom at 11. So
Anything further on this issue
Maybe it's 11:30.
regarding evidence of other crimes?
Aside from the side of the road, not at this time, no, Your Honor.
Do you have other witnesses to present on any other issue at this time?
No, sir, other than I had a summary witness for the side of the road, but, that would be it. As again, for in-camera proceedings before Your Honor, to get a handle on all of the sort of the 404 stuff that we're talking about.
All right.
No, that would be it. That's that side of the road.
We're going to take a break of about 5 minutes, and I will announce my decision regarding this other evidence.
all right, so we're taking a quick break here. Opportunity to just kind of touch on base. So, like I was saying, this has actually been one that's a trial that's been going on, maybe not in court for these particular murders, but something that's been looming over this community in South Carolina for quite a while now, for the last couple of years, and for several years there's been a swelling amount of cases that have come out from the Murdaugh family. One of the things that I wanted to point out was that and if you didn't see the comment and you just jumped in, I'll tell you real fast. So the documents at the South Carolina Attorney General's office have detailed that there's 19 indictments and 99 charges against Alex Murdaugh for tax evasion, money laundering, and forgery to fraud and several more. These go back for years and years and years, and it sums up to about $8.7 million.
Like our good friend John that was just on with us a little while ago, you begin to kind of pick this apart, see this progression as it moves toward that terminus. I think is critical. If you're willing to do this, would you be willing to take the next step in a case like this, where you're going to end the lives of these people that are, well, the son being a product of this relationship that you have with your wife that you've been married to for a long, long time? Could it get to that point where it is so over the top and to be able to mask it like that's the thing, right? We can hear them going on and on about the dog, if that is Alec on that tape, and some believe that it is, hear them going on, and within an hour or so, those lives, Maggie's and Paul, are at an end. Boy, that really puts this in a completely different light when you begin to think about the psychopathy that's involved in this. And it's quite horrific to think about.
All right. Well, we're going to hit a break. When we come back, it's just another weird element of this case. So many different weird elements. We'll take a break. When we come back, a lot more to discuss in the Alex Murdaugh trial.
This case shows that even the guy next door could potentially be a predator targeting your child.
When Reagan Beresford thought he was meeting up with an underage kid for sex.
All right, I'm not trying to get into this guy. I really am so over having to hear about these complete creeps. So what we are going to take a look at for a couple minutes here, there is see if I can pull this up for you real quick. without any kind of commercials or ads or anything like that. Though they do sneak in on us, it is something that we're gonna take a look at real quick. They got a yeah, but the yeah, doing an ad over here real quick. Let me check the comments real quick. Yeah, Veronica is saying that the judge will decide if he's letting any of these witnesses testify in front of the jury, and then the jury will be back. So, well, mafia family or the Murdaughs, and I think they're in a kind of a family. I think that they're kind of in a family on their own. You know what I mean? Like when it comes down to financial crimes, they're able to do things that, yeah, the bat phone's over here. They're able to do things that are unheard of, and it's because they've got this connection to the court system, and I think that's what any good mafia family has is they got ties to the police and the courts, and that's what this the Murdaugh family here is very much connected through their generational attachment and network within these counties. This is a quick couple minute video, and I'm not sure what it is. This is basically talking to just kind of catching up a snippet from CNN on some of the things that have happened in the trial. So we're gonna see what's up with this real fast. And boom, here we go.
From Snapchat was called on to testify for the state so she could authenticate this video. The video was extracted from Paul Murdaugh's phone months after he and his mother Maggie were killed.
The username is listed here as Paul9499.
You don't see Paul on the video, but you hear him laughing at his father, Alex Murdaugh.
Did you determine, reviewing the records, whether, excuse me, that account sent out that particular video?
Yes, it was sent on the same day, June 7th, 2021 at 7:56 hours Eastern time.
7:56 p.m., the night of the murders. That's less than an hour before prosecutors say Paul Murdaugh's phone ceased all activity, which they say was about 8:49 p.m. Remember, Alex Murdaugh told investigators he hadn't seen his family since supper time, that he discovered their bodies and called 911 at 10:07 p.m. What's especially significant about this video, besides the timestamp, is what Alex Murdaugh is wearing in it.
Yeah, his clothes are a
Notice the
big
long
deal.
pants and the short sleeve blue shirt. Testimony shows when police responded to the 911 call a couple of hours later, Alex was wearing something different, shorts and a white t-shirt.
They're foreshadowing their effort to prove that somehow he showered off, washed his clothes, made those clothes disappear, and changed clothes.
On cross-examination, the defense seemed to try and show that perhaps someone else might have known where Paul Murdaugh was, based on his Snapchat, and that person killed Paul and his mother.
Is it possible for, I don't know how it works, for some or all of Paul's friends to have access to his location through the app?
Yeah, if he made his settings visible, his geolocation visible to his friends, yes.
That plays right into what Alex Murdaugh told investigators after the killings, that Paul had been receiving threats following a boat crash he was involved in. A young woman died in that crash, and Paul had been charged with driving the boat drunk and causing her death. On the issue of motive, out of the jury's presence, the judge allowed testimony from this state witness. The chief financial officer of Alex Murdaugh's former law firm told the court she confronted Alex about hundreds of thousands of dollars in missing funds just hours before his wife and son were killed. The judge hasn't decided if he'll allow testimony about Murdaugh's alleged financial schemes. He's accused of defrauding clients of nearly $9 million before he was disbarred.
Had the firm received this $792,000?
No.
Did this matter ever come to your attention again at a later time?
Yes, that would have been in September, after we found some other misappropriations, and we had confronted Alex and he had resigned.
Prosecutors say Alex killed his wife and son to distract from his alleged financial fraud and prevent it from being exposed.
So there's you know, uh, a kind of a quick synopsis as to some of the things that have been happening around the Murdaugh family. So his son drove that boat. And for those that are watching, you guys know what's going on. You know, he drove that boat drunk into the bridge. Nothing came of it. You know, he wasn't tried. Or he was, not found guilty of any kind of crimes. He didn't go to prison. He didn't get, involuntary manslaughter. He didn't get any of the things that any other normal human being. If you get drunk and you drive and you kill somebody, you're gonna, that is grounds for a severe charge. You should get a severe charge if you're drunk driving and you murder somebody. You shouldn't get off with it. Otherwise, you'd have people around the world, at least around the country, just being like, "Hey, man, if I want to get off of a charge and I'm looking to kill my next door neighbor, I'll just wait till he's taking out the trash. I'll pound a fifth of whiskey and then I'll just run him over with my truck and then, be like, hey, man, I was drunk, accidents happen. Maybe he was, maybe he should have stayed more to the sidewalk. Maybe he shouldn't have been walking through the parking lot. Maybe whatever. But to not have anything happen. And then you follow this money trail where he's got almost $9 million worth of alleged financial crimes that are looming over him right now. And then you back that train up to what this previous witness said, which is all of this roadside shooting nonsense, as he called it, which was this hired hitman that Alex Murdaugh had put on task to kill him. For allegedly allowing his life insurance to go to his son, Buster. All these crazy things. And this guy is, and then he's come out and said that he's got a pill addiction. He's got, all these issues. And yeah, we get it, buddy. You got problems. The biggest problem I feel that he's facing is the fact that he more than likely murdered his wife and his son. And he's got $9 million of looming, charges that he apparently is broke and can't pay, which is wild that he would say that. Any normal human being, any of us, me, okay, I'll say me. When I hear someone say they're broke, I'm like, hey man, I got you. Let's get something to eat. I don't hear someone when they say, yeah, I'm broke, I got no money. Then he's like, all right, we'll settle on $1 million. All right, we'll settle on a straight mill. Call it good, because I know you got no cash in your pocket. If I ever say I'm broke and I got $1 million in my pocket, I encourage and I give the green light for anyone listening to punch me square in the throat. And if you don't, then I have to question your judgment because I would deserve it wholeheartedly, like with no questions asked. Just so you know, we are not back in yet. So I'll throw this up on screen though, so you guys don't have to worry about missing anything from the trial here. And I appreciate you being a part of this right now. It's been going on for a little bit, and we've been covering some trials. We went from the Darrell Brooks trial, Mark Jensen, who again in April we have his. We're looking at his sentencing for first-degree intentional homicide, which he was found guilty of. Which, if you didn't think that was going to happen, you really weren't paying attention, because that guy. And when I went to court and I sat in there and listened to the court that one day, and I'm looking at him, and he gets up and kind of looks over at me and just kind of stared for a minute. I swear to God, I felt like he stole my soul. Like he just had dead eyes, and he had that zombie serial killer look to him. It wasn't good. It wasn't something I was happy to be a part of. And it's funny because I don't really get starstruck. I was just down in LA. You work with people in the industry down there that are, pretty well-known figures in the Hollywood community. And you just kind of get used to seeing them. But like, when you get close to these criminals, it really, like the presence that they have, that aura, the whatever it is, that energy, it gets you kind of like, you get the goosebumps, like, oh my God, and I've had a chance in the last, year to sit down and talk to, singing, recording artists and people and actors and whatnot that have been awesome, and nothing, just like, what's up? How you doing? Let's have a conversation. But that guy was one of those like, I don't want to make eye contact. And it wasn't like I was excited about it. You know what I mean? Man, it's wild. But yeah, broke and then saying you have $1 million and all these properties, you're sitting on equity, pal. You've got the ability to pay, and you should be paying. I mean, you should pay. This attorney that would the previous witness, I'm loving him. He was taking zero shit from the attorneys for Murdaugh. I love when he said, like I said before, that he was like, so when they told you what you were going to do, and he's like, no, nobody tells me what to do. I was like, boss, man, everyone's, pulling him out and swinging him around the courtroom right now, just letting him know who's in charge. So this will be interesting. Now, if you haven't seen any of the documentaries or listened to any of the podcasts or anything else going on around this case, I'm going to pull up a list of them for you guys to take a look at. Just going through things, so you have a chance to kind of see what's, and here's some of the details, because mind you, there's people who have a lot more information about this case than I do. And I've got some personal information because my network here is close to it. Used to work in South Carolina in Hilton Head, down there in that area, Port Royal, and knew the family, knew the whole situation pretty well. So we're going to get a chance to talk to some of the locals down there and get a look at the place firsthand. So I definitely want to share the stream and get a real in-depth look at what's going down and be a part of it with us from the ground level. So
this issue is before me on the motion of the
just
state
share the stream, please. Share the
to admit evidence pursuant to Rule 404B of the South Carolina Rules of Evidence, and also under the theory of race geste. Of course, the defendant is on trial for murder of his wife and son. And over the course of the past several days, we have conducted an extensive in-camera hearing. The court has reviewed all of the exhibits submitted and I've considered the testimony of each and every witnesses, and I have concluded that the motion should be granted. Under the law of this state, evidence of other crimes is not admissible to prove the character of the person in order to show action in conformity therewith. An exception, however, exists when the evidence is offered to show motive, identity, the existence of a common scheme or plan, the absence of mistake or accident or intent. And before admitting this evidence, the court must first determine if it's relevant. Our rules define relevance as evidence having any tendency to make the existence of any fact that is of consequence to the determination of the case more probable or less probable than it would be without the evidence. After determining relevance, the court must determine if the evidence falls within an exception to Rule 404. In determining if an exception exists, the evidence must be logically relevant to the particular purpose or purposes for which it is sought to be introduced. And this requires the court to analyze whether a logical nexus exists. Evidence is logically relevant when it reasonably tends to prove a material fact and issue. And of course, the evidence of any other crime offered to be admitted into evidence or proven or testified to must be proven by clear and convincing evidence. And the court is required to conduct an analysis under Rule 403, which weighs the probative value versus the prejudicial effect. According to the state, the nexus is supported by the unusual circumstances of the murders, in that the defendant was the last person to see his wife and son alive, and the one who discovered the bodies, all in a relatively short period of time. The state has presented evidence in this in-camera hearing, evidence of numerous financial crimes allegedly committed by Mr. Murdaugh. The state argues that the logical nexus between the murders and other crimes is that the looming exposure of financial crimes provided motive for the murders and is evidence of malice, an essential element of the crime of murder. On June 7th, the defendant was confronted about $792,000 missing from the law firm. Beyond that sum, the state contends that millions of dollars were misappropriated by the defendant, and this misappropriation would imminently be exposed. We've heard from the bookkeeper for the law firm, Gene Seckinger, who testified to confronting the defendant on the day of the murders about the missing $792,000 from a case that he worked on with attorney Chris Wilson. She had previously questioned Mr. Murdaugh concerning the improper disbursement of fees in the case of the state versus Hirschberger, wherein it's alleged that Mr. Murdaugh sought to put the fees in the name of his wife, Maggie, to hide them from discovery in the boat case. She testified that the firm conducted a forensic audit, which then documented millions of dollars of misappropriated funds by the defendant, funds that the law firm had to replace. The defendant and his son, Paul, have been sued following the fatal boat crash, and the defendant had been served a motion to compel production of his financial information. On the day of the murders, according to the testimony, the defendant was preparing for the motion to compel, which was set to convene in 3 days. We've heard testimony from Jan Milanowski, the president and CEO of Palmetto State Bank, who provided testimony and documentation to millions of dollars owed by the defendant to Palmetto State Bank, all while the defendant was frequently carrying a substantial negative account balances. Michael Gunn, a consultant with Forge Consulting, testified that the defendant created a fake bank account using the firm name of Forge. And according to the testimony of Ms. Seckinger, this fake account was used as a main depository for a substantial, if not most of the misappropriated funds. We heard testimony from attorney Chris Wilson about confronting the defendant about the missing $792 and the personal sum to him owed of $192,000 was later discovered. And that testimony or that confrontation took place on June 7th. Mr. Murdaugh later confessed to having stolen those funds along with committing a multitude of other crimes, and also claimed to be suffering from drug addiction. We heard from Michael Satterfield, who Mr. Murdaugh, according to him, represented in a lawsuit against himself involving the death of Gloria Satterfield, Michael Satterfield's mother, who was the housekeeper of Mr. Murdaugh. He testified that he'd heard of through the reports that money had been recovered in the case. And when he discussed it with Mr. Murdaugh told him that no money had been recovered and it would take a year or so. It was later revealed that money had been recovered and that a confession of judgment was later issued in the sum of $4,304,000. Also received testimony from Mr. Carson Burney from the State Attorney General's office, who traced funds in and out of the bank account. I find that the jury is entitled to consider whether the apparent desperation of Mr. Murdaugh.
No, we're at the point where we're trying to find if these evidence and witnesses are admissible to the trial.
Being exposed for committing the crimes which he was later charged with. Resulted in the commission of the alleged crimes. While motive is not a necessary element, the state must prove malice, and evidence of motive may be used to prove it. And in this case, since the identity of the perpetrator is a critical element that must be proven beyond a reasonable doubt, evidence of motive may be used in an attempt to meet that burden. This evidence of other crimes is admissible and it's non-propensatory, as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground or than the specific charge. Thus, it is non-propensatory evidence and is supported by state law. Therefore, this non-propensatory evidence of other crimes is admissible under Rule 404B and Rule 403, and that the evidence, which may be prejudicial, but it's more probative than prejudicial. As to res geste, the state alleges that Mr. Murdaugh was under immense pressure after being confronted about the missing fees, the upcoming hearing on the motion to compel his financial information, his dire financial straits, and the looming exposure of this criminal activity. And the state contends that that situation led to the murder of Maggie and Paul Murdaugh. Our courts have held that where evidence of other crimes is an integral part of the crime for which a defendant is charged, or it is needed to aid the jury in understanding the context with which the crime occurred, then that evidence is admissible under the theory of res geste or res gesti, as some might pronounce it. I find that the activities and conduct as of the defendant on June 7th, 2021, as testified to, is admissible under res gestae, and that this evidence furnishes a part of the context of the alleged crime. It's necessary to the full presentation of the case, which the state is entitled, particularly since the state is relying heavily on circumstantial evidence. I find that it is so intimately connected with and explanatory of the crime charged under the theory that the state is seeking to prove, that proof of it is essential to complete the story. Our courts have further declared that where the full presentation of the evidence is admissible, that there is no reason to fragmentize the events under inquiry by suppressing parts of the res gestae. Further, in State v. McGee, the court held that where res gestae, evidence of res gestae or part of res gestae is properly admitted, then no 404B or Lyle analysis is reached. However, as to the finding of admissibility of evidence, which I have done, and the finding of it within the res gestae, I've nevertheless conducted a Rule 404B analysis or Lyle analysis, though not needed. In conclusion, the state's motion to admit the other evidence or evidence of other crimes is admitted. I will file a more formal order granting the state's motion later today. Are we ready for the jury?
I believe we are.
Your Honor, one point on Your Honor's ruling. I don't know that they're getting into the financial stuff immediately, but we do have a proposed limiting instruction that we would request the court to give at the time they offer the evidence.
Okay. Yeah, thank you very much. And certainly upon request of the defense, the court is required to give a limiting instruction.
The schedule will probably be late afternoon or tomorrow when we started to cross into some of those financial witnesses.
Have you reviewed the defendant's proposed limiting instruction?
Looking at it right now, Your Honor.
So I'm putting together a play-by-play for you of what you need to get caught up on for the last 2 weeks of trial. I'm going to post that over on my Facebook page, and I'm going to try to do a post on YouTube as well, just to make sure you guys kind of know some of the details and some of the key point facts and witnesses' testimonies and evidentiary findings that have kind of built this the admissible case against Alex Murdaugh here, which is what the judge is saying. Like, yeah, you know, there's plenty of evidence to continue. And you'll see these things. And I know there's probably people that are much more legally versed than I am. Well, they're going to, you know, they'll do things like they'll say, wait, we're pushing for a motion to dismiss. Once the prosecution rests their case, defense will say, all right, well, we'd like to have a motion. We're putting a motion to dismiss this trial based off lack of basically saying the prosecution hasn't done a good enough job to prove beyond a shadow of a doubt that Alex Murdaugh is guilty. So it happens in all trials, and it's kind of just standard process and procedure. But it is crazy that you kind of get on the edge of your seat, like, oh my God, what if, you know? And in these places, these cases with judges and attorneys, the likes of these, with such a an influential family and how much control they've had in that area, these are times when you kind of like, you do have a reason to hang on the edge of your seat because you don't know. You really don't know. Something crazy might come through and it'll be one of those holy shit, I can't believe it moments. So
Before the testimony is offered, Your Honor, from
Probably not late today, but certainly tomorrow.
All right. Well, you have an opportunity to submit your own proposed limiting instruction or to confer with defense counsel and see if you all agree.
Absolutely. We'll work on that, Your Honor.
Yeah. Of course, you have the other question of res geste and whether or not a limiting instruction is required for res geste testimony.
No, I understand, Your Honor, and I guess I understood the scope of the court's ruling to go beyond res geste or gesti and to include prior.
He is
prior
correct,
events
Judge.
He wasn't confronted about on June 7th. Now, if the court's ruling is limited to the confrontation on June 7th and about that transaction, then it would be res geste.
It's not limited to June 7th. June 7th also includes res geste, but the ruling includes
it's justi, Judge. Do you understand that?
all evidence of financial crimes that may likely have led to a motive, lend itself to motive for the crime committed. And that may be before or after.
Yes, I understand the court's ruling. I will, for the record, when it's offered, just make a formal objection to protect the record.
Yes, sir. I understand.
Showing no disrespect to the court.
No, I understand. Okay, we're ready for the jury?
State's ready to proceed, Your Honor.
Bring them on.
Oh, here comes the jury. Again. And again, if you would, please share the stream. If you're just tuning in, if you've been for a little while and you're not able to help support the stream via the way of stars or super chats, anything like that, sharing the stream out to as many places as possible. I have a series of groups I share it out to, people that I feel are interested in the trial, and I really hope that you do the same to help support kind of the effort we put into, myself and my team out here, to give you guys as much in-depth coverage as we can with not just these trials, but any of the other things that we do. Be it, covering a protests, demonstrations, riots, rallies, or any other culturally, I feel, relevant events that are taking place or things that I just find interesting. So I hope that you find them interesting as well. And if you really want to help support what I do here and what we're doing here as a community, share it out to your personal community, friends, family.
Thank you. Good morning.
It'd be amazing how many people we're unaware that this is even going on for all of us that are in the know.
Well, 11:58. It's still morning.
Definitely want to show up
on day
and
number
in the best
11.
we can as far as just sharing the stream, guys.
Call your next witness.
From the state of South Carolina, we now call Miss Michelle Smith to the stand.
How you doing? Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God? Yes. Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
So you want to catch the name of this witness for me, please?
Shelley Smith.
And the spelling, Shelley Smith. E-Y.
Take a deep breath.
Yes,
LLY.
What is your first name?
Michelle,
Spell that, please.
Mushell.
Where'd you get that name from?
My auntie named me.
And where did she get that name from?
I don't know.
Is it Michelle with a U?
You, yes, correct.
During the course of this, if you don't mind, is it okay if I call you Miss Smith or Miss Shelley or Shelley? I really don't know what's going to come out of my mouth sometimes. Is that okay?
That's okay.
But do you go by Shelley?
Yes.
Please tell these folks, Ms. Smith, about Michelle Smith, where you were born, where you were raised, please.
Hampton, South Carolina.
And ma'am, if you don't mind just pulling this up a little bit and speaking into it.
Okay, thank you.
Thank you. Go ahead.
I was born in Hampton County. Have 4 grown kids. I was born in Hampton County, 4 grown kids, 8 grands, and I worked for the Hampton County District for the last 28 years. Food service is my professional.
Pull that chair up. I just want you to be comfortable.
And would you stop telling the lady what to do? She's just fine. Let her speak.
Yes.
Then you said 6 to 8 grands.
It's 8 grands.
Heard her, man. Grands. Grandkids. I love that Southern talk.
Raised where?
Hampton, South Carolina.
Okay. Where'd you go to high school?
Wade Hampton High School.
And what did you do after high school, Smith?
Got married, raised my kids, and that's it. My profession. That's it. Mhm.
And that is the hardest profession, raising children.
Yes.
You had 4 kids.
4 kids.
And when you were raising them,
6 grands.
you were raising them, taking care of
Yes.
the family.
Mhm.
And are any of your family here today?
Yes, my brother and my daughter.
What's your brother's name?
Michael Smith.
Michael Smith, will you stand up? Is that your brother?
Yes, that's my brother.
And who else is here?
My daughter, Rochelle.
Miss Rochelle, will you stand up? Thank you. They here supporting you today?
Yes.
Don't take this the wrong way, but other than raising a family, which is the hardest job, were you doing anything else during that time period?
No, till 1995. I started working at the school district.
Okay. Did you work in your church while you were raising your family?
Yes, I worked at church.
Okay, and that's what I'm asking. What did you do with your church while you were raising your family?
Usher, kitchen ministry.
Kitchen ministry?
Mhm. Yes.
And how long did you do that?
Oh, all my life, church.
Are you still doing that?
Yes.
And you don't have to name your church, but where's your church located?
Fairfax, South Carolina.
So at some point after your children moved up in years or got older, did you start another profession?
Yes.
Okay. And tell the ladies and gentlemen what that was, please, ma'am.
Private home care.
I'm sorry?
Private home care, caregiver.
How did you get into that?
My aunt.
And was she in that business?
Yes, she's an LPN. Yes.
An LPN?
Yes.
Licensed practical nurse?
Yes.
And when did you get into the home care business?
Probably about 10 or 12 years ago.
Now, prior to that, had you already started with the school?
Yes, I'm still at the school also.
Okay. Tell them when you started with the school.
The school in 1995. That's correct, 1995.
And what school did you start with?
At North District Middle School in Warrenville, South Carolina.
North Central Middle, Varnville.
North District Middle School.
North.
Yes.
What did you do for them?
Food service.
And how long did you do that at that school?
I've been there for 19 years at North District Middle School.
After that, did you change
Yes.
locations?
6 years later, I went to Wade Hampton High School.
And for those of us that don't know, where is that?
Warrenville, South Carolina.
And you've been there 6 years?
Oh, no, 6 years at Wade Hampton High School.
So total years in the school system is what?
28 years.
And you're still there?
Still there.
So you started home health care while you were still teaching school, or
No.
still going to school?
Going to school, working food service.
And will you please tell them, you said your aunt got you a business. Were you working with one family at a time, or did you have?
Different families at a time. Different families.
And how long would you stay with the family once you became their caregiver?
It all depends on how long if they're deceased, I will move on to someone, another family.
So is it fair to say you'd stay with the family until the person passed on?
Passed on, yes, correct.
And then how'd you get other jobs as far in that caregiving profession?
My aunt always called me and said there's a job, and she let me put me on that job.
So Guten Tag. Before we get to this case, your schedule would be what when you were still working at school?
Yes,
and
at school.
caregiving?
Yes.
Okay, so what was your typical day like?
My typical day, I leave home at 7:20, have to be to school at 8 o'clock that morning. And I will stay there till 1:45, make my deposit for the school, then leave and go to my next job.
I appreciate all the comments, you guys. Thank you very much for jumping in here, sharing. Hey, real quick question. Where's everyone tuning in from? I know we got Christelle. I want to make sure I'm saying that right. Coming in from Germany. What part of Germany? And where's everyone in the country watching from or around the world?
Ms. Smith,
line us up in the comments.
how it came about that you started working for the Murdaugh?
It was a job opening. I think one of the caregivers mentioned it to me, and I said, yes, I'd be interested in going. And now that's how it started.
And one of the caregivers mentioned your name. Do you know who that was?
Yes, sir.
Okay.
It's Barbara Mixon.
It's Barbara Mixon?
Yes, sir.
So there's an opening and your name got brought up?
Yes.
And can you tell these folks when that was? When did you start working for
Australia?
Murdaugh family?
Well, good eye, mate.
October of
Sorry.
2019.
Hello. I can't help myself. I'm sorry.
What was your role as a
Dave, we
caregiver
know,
specifically for the Murdaugh?
Miss Libby, taking care of Miss Libby. Miss Libby.
Was Mr. Randolph, I knew him as Solicitor Randolph Murdaugh, but was Mr. Randolph, was he there living when you started there?
Yes, he has, yes.
And then that's what we've referred to as Almeida?
Yes, Almeidas, yes.
Lost Wages, Nevada. Dave's down in Portland, Oregon.
What was your primary job as the caregiver? Were you there to take care of Solicitor or Mr. Randolph, or was your primary job for Miss Libby?
Miss Libby.
Did you also ever tend to
Bremen.
Mr. Randolph's?
Yeah, every night and then.
Keep me in mind. I'm looking to do a European
But
tour.
your main
Maybe I can
focus
stop in
was
and say
Miss
hi.
Libby, yes.
And then Veronica down in Florida. But
From
Christelle, keep
October
that in mind.
19th up to June 21st, Ms. Smith.
I'm going to take the show on the road, guys.
And I want to be very delicate in this question. I think it's something that affects everybody in the world, this jury there, but did Miss Libby's condition get worse?
Yes.
And she's suffering from something that affects all our families, it's Alzheimer's?
Yes.
And that got worse from the time you started until June?
Yes.
Well, in June of 2021, how would you describe Miss Libby's condition?
Alzheimer's, couldn't remember anything at times.
In your opinion, as her caregiver, was she aware of what was going on around her?
No.
All right, specifically, in June of 2021, Ms. Smith, or May, June of 21, tell these folks what your school schedule was and then your work schedule with the Murdaughs.
Okay. My school schedule was 7:20, I will leave home, be to school at 8 o'clock, and I leave there at 1:45. Go home, make my deposit at the bank, go home, rest, come back to work at 7:45. Had to be there at 8 p.m. that night. I would stay all night and leave 7:45 the next morning, leave there and go back to the school.
So was that the shift you were working for the Murdaughs
Yes,
primarily?
yes,
From 8 p.m. to 8 a.m.?
yes.
When did you sleep after you went to school?
Took little cat naps every now and then.
But would you go home after you made your deposit?
Yes.
You would rest?
Yeah, that's for a couple of hours.
And then did you have a change of clothes at the Murdaughs for when you went straight to school the next morning?
Yes.
Email me over your info. We'll start doing pen pal stuff, and then.
Well, ma'am, I'd like to take you to June 7th of 2021. If you'll go back there, if we can take them back in your mind and take this jury back there right now, please, ma'am. Were you working as a caregiver for Miss Libby Murdaugh on June 7th of 2021?
Yes.
Now, had Mr. Randolph, again, I know Ms. Solicitor, but had Mr. Randolph's condition worsened? Had he gotten, was he in the hospital? Was he there when you got there on June 7th?
No, he was not.
Do you know where he was?
He was in the hospital.
What time did you get to the Murdaugh's, Miss Libby's residence and Mr. Randolph's residence on June 7th of 2021?
7:45.
Okay. And that's the time you were there?
Yes.
And you're never late, are you?
No.
Okay. And is somebody waiting to leave?
Kids will be late though.
Yes.
Be clear.
And
You
this
may be
night
on
who was there?
Kids will be late.
It's Papa mixing them.
Yeah, look at Alex's face, man. He looks pissed.
I'm sorry.
Understanding your words, can you speak maybe louder?
Okay.
I know you can't change your voice, but
I love these.
Yes, sir.
a little louder, please.
These little
closer,
comments that
right?
come in about HIV or diabetes or whatever, Sorry, but I got to block you because it's garbage. But so you're blocked, and then I'm going to delete the comment.
You tell us what Miss Libby, when you got there on June 7th of 2021, shortly before 8, where was Miss Libby?
In the bed.
And as a professional caregiver.
And that's my email
And this
address.
was what
If anyone
time of
has
night?
information,
8 o'clock at
comments,
night.
concerns, shoot me an email. I promise I'll get back to you.
If one of your patients that you're taking care of is in the bed resting, do you like to disturb them?
No.
If they're sleeping, do you want to wake them up?
No.
So when you got there, was Miss Libby in bed?
She was in bed, yes.
And do you get briefed by Miss Mixon on what happened during the day, or y'all exchange, hey,
Just come in with, change or if she need to be changed or whatever like that.
make sure that
She's
dry?
She's dry. It's okay, yes.
And so where's your desk? What's your position when you're there, when you're in her room, Miss Libby's room?
Yes.
Okay. Where do you sit when you're in the room? I mean, what do you do to take care of her?
In a recliner. Have the recliner. Sit there.
And is there a TV in the room?
Yes.
And is the TV usually on when you're there with Miss Libby in the evening, or does it?
Yes.
Okay. Was it on this night?
It was on, yes.
And do you remember what y'all were watching? Or what was on TV?
American Saves, a game show.
Say it again?
American Saves, the game show.
Okay. How long has that been on?
It's stays on, it repeats. It's afterwards repeats itself.
What channel is that on?
The Game Network show. Channel, excuse me.
At some point on the evening of June 7th of 2021, did you see Alex Murdaugh?
Yes.
Okay. Do you remember what time it was? Approximately.
The game show was on, so it had to have been 8 o'clock, 8:30, 9:30, somewhere up in there.
8:39, 9:30?
There's something up in there.
Is it fair to say it was later in the evening?
It was late in the evening, yes.
And you had worked that schedule for that 8 p.m. to 8 a.m. shift for how long?
2 years.
2 years.
2 years.
Was it unusual to see Alex Murdaugh at that residence that time of night?
Yes, on my shift, yes.
And that's the only shift you'd work?
Yes.
So the 8 p.m. to the 8 a.m. shift, it was unusual to see Alex Murdaugh there visiting, correct?
Correct, yes.
Have you ever been over there before that time of night?
I think different off and on, it all depends.
When he got there, can you tell the jury what happened?
He called the house and told me he was outside.
He called the house?
Yes.
What phone did he call? Terrible question. I mean, was it your phone, the house phone?
The house phone, the house phone.
Okay. And when you answered the house phone, what did he say?
He was outside to let him in.
He was at the house,
Yes,
right outside the house,
yes,
and he called you,
yes,
and he said, let me in.
yes.
And after he called you, how long did it take you to go open the door to let him in?
About 5 minutes.
So he was right there
Mhm.
at the house.
Yes,
You let him in?
of course, yes.
Do you remember what he was wearing?
Shorts
Okay.
and a t-shirt.
Do you remember what kind of shoes he had on?
Those cloth shoes, like Sperry's, that type of material, like Sperry's, that type of material, cloth shoes.
Cloth shoes?
Yeah, like cloth.
Sperry's.
Yes,
And you said something called Spears?
something like Sperry's, that, that kind of, but it was cloth. That kind, yeah.
Wasn't boots?
No, it wasn't boots, no.
Are you familiar with tennis shoes?
Yes,
Was it tennis shoes?
no, it wasn't tennis shoes.
Cloth, Sperry type shoes?
Yes,
Did he have any socks on?
no.
Tell the ladies and gentlemen of the jury, could you describe Alex Murdaugh's demeanor on June 7th when you were there with him and his mother Libby?
He just
How was he
came,
acting?
like, fidgety, this came in,
Speak up, please. ma'am.
fidgety, I'm thinking, it's normal.
She
Like
said
it was
that's normal.
fidgety, like, yeah,
Fidgety.
yes.
So saying, okay.
Man, they love correcting people. You
And,
know what the hell she said,
um,
man.
Did he tell you why he was there?
No, he just came to see his mother.
Did he talk to his mother?
But she was asleep, yes.
She was asleep. Okay. And what did he do? What did Alex Murdaugh do when his mother was asleep?
He came and sat on the bed, because we was asking me what I was watching, I said American Says, I said a game show.
Did he say anything to his mama?
We said, hey, Mom, how you doing? Just came to check up on you, yeah.
Did he say why he'd come to check up on her?
Because Daddy was in the hospital, called him Hansel, was in the hospital.
And in your opinion, as being there, her caregiver, did she even know that he was there?
No,
The objection's overruled.
You said no?
no, no.
How long did he stay in the room with y'all? I say y'all, for the record, you and Miss Libby, I apologize.
About 15 to 20 minutes, 20 minutes.
Was he moving around the room?
He was laying on the bed,
Did he have his phone with him?
yes.
Was he looking at his phone?
Yes, he was on his phone, yes.
I'm sorry, ma'am. What?
Yes. Mhm.
After that initial conversation, you said, he said, I'm here.
Mhm.
Did he have any other attempt to have any other conversation with Miss Libby?
No,
Did he hold your hand out? Did he ever hold her hand?
yes, he did hold her.
He hold her?
Mhm.
Did
She
you
was-
talk to her?
Yeah, she was in the bed, yeah. Yes.
And her condition then was what?
She was, sleep off and on, sleep.
Yeah, this lawyer he's like to be.
How long did he stay there?
Crazy.
I forgot.
20 minutes, about 20 minutes.
$20.
About 20 minutes.
What happened after that?
He left.
Your shift ended when?
8 o'clock the next morning.
At some point after that, did you get a call from Miss Mixon?
Yes,
Did you learn what had happened at Moselle?
yes.
At some point after that, did you get a call from a family member? I really don't know who it was, but
Yes, yes,
do you remember who it was?
yes.
Okay, who was it?
It was Randy,
Randy Murdaugh,
Randy Murdaugh, yes,
Alex Murdaugh's brother.
yes.
And as a result of that, were you expecting people to come over after that?
No,
After that phone call, were you expecting people to come spend the night that night?
yes.
Okay. Who was going to come over?
Randy told me, John Marvin, Buster, his girlfriend, and Alex.
John Marvin, Buster and his girlfriend, and Alex.
Yes.
And did you, and in fact, see them later on that night? Or that morning, the next morning, I'm sorry. Did they come to Alameda after you got the call from Mr. Andy saying they were coming? Did they come?
Yes, they came, yes.
And at some point later on that morning, did you see Alex Murdaugh again? Did you see him again that morning?
No.
Did he ever come looking for glasses?
That morning, that night, he was in there. He came with glasses. He said he couldn't sleep.
And Mr. Randolph, or Solicitor Randolph, died shortly, a couple of days after that?
Yes.
Now, you were working the 8 p.m. to 8 a.m. shift. Were you asked to work more after this to get the family through this? Were you
Yes.
asked to help more at the house?
Yes.
And were you happy to do that?
Of
Yeah, he's
course.
taking a long way around the mountain.
And do you remember the day of Mr. Solicitor, I'm going to call him Solicitor, that's the way I know him, Solicitor Randolph's funeral?
Yes.
And I've been reading through all this stuff. What's a repast?
A repast is when everybody come back after the funeral and eat.
Everybody comes back and eats?
Yes.
Well, after the funeral, did people come to Alameda, so like a visitation after a funeral?
Yes.
Okay. Did folks come over there then?
Yes.
And was the family there then?
Yes.
And during this repast, visitation, where were you? And I said, what was your job during that, or what were you doing during the visitation?
I was in the room with Miss Libby. Just back and forth.
And sometime that afternoon, did you see Alex Murdaugh?
Yes.
Okay. Tell the jury about that, please.
He came in the room, you know,
You'd speak up, please, ma'am.
he came in the room and speak that, you know, spoke like he always do.
And what did he tell you?
That he was sitting at the house. He was at the house.
Say it again.
He was at the house.
And I'm not 100% following you. He was telling you or saying to you that he was at the house?
Mm-hmm.
When?
The night of the murders.
The night of the murder?
Yes.
What was he telling you about that he was at the house the night of the murder?
That he'd been there 30 to 40 minutes.
Was he telling you that?
Sorry, guys. I'm
Did he
getting a
ask
little
you anything about that when he was talking to you?
cold. He was telling her how long he was there. That's odd.
Yes.
Did he indicate to you what he wanted you to do with that information?
No. Mm-mm. No.
What did he say?
He just said that he was at the house for 30 to 40 minutes. That's it.
You said what? Was he there 30 or 40 minutes that night?
Not to my recall.
Why are you crying, Ms. Smith?
Because they're a good family, and I love working here. And I'm sorry all this happened. They're good people, you know.
But he wasn't there no 30 or 40 minutes, was he?
No.
Can't lead the witness.
Was he there for 30 to 40 minutes?
Did that conversation upset you?
Somewhat.
You upset right now?
Yes.
Did you call anybody about it?
My brother.
You called your brother after that conversation with Alex
Yes.
to tell him about that conversation?
Yes.
And just to be clear,
Yeah, look at Alex in the bottom right there, man. He is not happy. Not happy.
what was the statement he said about how long he was here?
30 to 40 minutes.
But his phrase was, I was here, or you know
I was here 30 to 40 minutes.
Yeah, that's some guilty ass talk right there. In case anyone asks, I was here for 30 to 40 minutes. Why are you saying that? Just saying it. Why are you saying that? Why are you making it weird?
Not to pry, but I can't help it sometimes. What else was going on in your life right there?
Just,
Ooh, Candace.
just working.
When the flow,
Hours and
the dam
hours.
breaks, the flow will be damming. Ooh,
I understand what you're saying.
preach.
When you gonna get married?
I was planning on getting married. I was planning on to.
Ooh.
And had Alex Murdaugh mentioned anything to you about your upcoming nuptials?
Yes.
And when was that?
Chris and John, you guys are probably right. She might be just really scared.
Yeah,
She might have got some threat.
The day after this?
I'm thinking it was,
After
yes.
the conversation
The
you said?
documentary.
Where were you?
The guy said was
At
that
at the house.
never question the Murdaughs because they would just.
And what did he say about your marriage, your upcoming potential marriage?
I heard you was getting married. I said, yes. He said, if I could, just let me know because I know wedding's gonna be expensive. I said, well, thank you.
The wedding's gonna be expensive?
He said, wedding's gonna be expensive. I said, well, thank you.
He offered to help?
Yes, he offered.
Here we
That's the type
go.
of person, a good person.
And did he ever mention the wedding to you before?
No. Mm-mm.
Did you mention that to him before?
No,
I was just scratching my eye. That was like.
Did you have a conversation, anything
really,
else about
though.
your job?
Yeah,
Were
some
you working at the
payoff.
school?
Yes, at the school, yes.
Did Mr. Murdaugh mention to you about your school and your position there?
Yes.
Tell him what he said, please.
He said that, if you need a position at school, my good friend is there. I said, yeah, I know, worked at the school, the principal.
I believe you testified, did you help out more than just your regular shift the rest of this week?
Yes.
That week after
Yes.
the murders and Solicitor Murdaugh's death? Were you working full-time then, trying to help?
Yes.
Was school out then?
No.
So you still going to school and helping?
Yes.
And after Mr. Randolph's funeral, did you have an occasion to see Alex Murdaugh early one morning?
Yes.
Do you know how long it was, how many days after the funeral, Mr. Murdaugh?
3 days, I think, 3 days.
Can you tell the ladies and gentlemen of this jury what time it was in the morning that you saw Alex Murdaugh?
6:30 that morning.
Say that again.
6:30 that morning.
And that had been a part of your regular 8 to 8 a.m.?
Yes.
And did he call you and tell you he was coming?
No.
You didn't? Had he called you on June 7th and told you he was coming?
Yes.
And he was right outside the house?
Yes.
And this morning at 6:30, he did not call you?
No.
How did you know he was on the premises?
He knocked on by the bedroom, the window.
Knocked?
Yes, on the wall.
Or did you hear him say
He
anything
said-
after that?
He said, I'm outside.
Say it again?
I'm outside.
Had he ever been there at 6:30 in the morning before that? While you were working there?
No, sir.
Never?
No.
And tell the ladies and gentlemen of the jury what you observed that morning when you saw Alex Murdaugh.
He came in the white truck.
Well, there's still funeral stuff's not in the World Road. There's still funeral equipment in the yard.
Yes.
Like what?
The tent was still there and the big old building, they put the food in, had out there.
Like a food truck?
Yeah, food truck, yes.
Was that blocking?
Were there
your view
guns
from-
enclosed in the truck?
Yes, blocking view, yes.
So when you saw Alex Murdaugh this morning at 6:30, what did he do after he knocked on the door? Did you let him in?
Yes.
Then what did he do?
Came inside.
And was Miss Levy sleeping?
Yes, she was still asleep.
Okay. Did he go check on Miss Libby?
No, he didn't give me one.
He didn't go check on her?
I can't remember.
Well, what did he do then?
He came inside.
And did he have anything or was he holding anything?
He had a blue something in his hand.
Say that one more
A
time.
blue something in his hand, something blue.
A blue something in his hand.
Mhm.
And can you show me how he was holding it?
Like this.
Is it all right if I touch it?
Yeah, that's fine.
How was he doing it?
Like this. Like that.
Holding something like this?
Yes.
And what did it look like?
That was a solid yes for
Like a
consent.
blue tart, like a tart.
Blue?
Blue.
Okay. Was it vinyl?
It's like a tart that you put on a car, you keep your car covered up.
Big thing.
Yeah, blue.
And was he holding it like this?
It's holding like this.
Could you tell if there was anything in it or do you know?
No, I couldn't tell.
But not holding like this?
Mhm.
Did he say anything when he walked in?
No,
What did he do when he walked in?
went upstairs.
Man, no wonder he wasn't happy about her.
Of course, no. United States 230. $223, $222, $413, $412. At this time, without objection, I'll save the other two. I didn't call it.
You're admitted without objection.
You testified Mr. Murdaugh came in your Alameda residence that morning. This is States 223. Do you recognize that?
Yes,
What is that?
upstairs, going upstaiars.
And is that where he went, Alex Murdaugh, that morning,
Yes.
carrying some blue thing?
Mhm.
And this may be duplicate. If it is, I'm sorry. That's 222. Same stairs, same house?
Yes.
States 413. What is this?
That's the bedroom,
Where in
Yeah, no
Alameda
alibi
is this
there.
bedroom? First floor, second floor?
first floor.
Is this where Miss Libby stayed?
No. Mm-mm.
And 412? Is that the same?
Yes, same bedroom, yes.
Yeah, this guy's got a long history of just being able to make people like be quiet and go away. So
I'll show you what's marked 411. Don't call out the answer. This is States 411 for identification at this point. Do you see the blue object in the center?
Yes,
Does that appear to look like the object you've described?
yes,
You saying yes?
yes,
Is it blue?
it's blue.
Is it vinyl?
Yes,
That appears to be the same thing you saw the defendant holding this early morning hours when he came in the house. Is that correct?
it looks so, yes.
You know, this is States 411 we'd offer at this point. I don't know how to ask it except ask it. Did you ever see that blue thing unfolded when you were that morning, or you saw him carrying it?
It was unfolded
Okay, where'd you see it?
in the bedroom,
And where in the bedroom?
on the chair.
And again, I'm not clear. Was that in one of these pictures we showed you? What chair? Did they disappear? Oh, I'm sorry. I apologize.
He said, did they disappear?
Was that on one of these chairs in this?
Yes,
Okay, and I'm referring again to 412. You saw it on the chair?
yes,
Did you come, you ended up leaving at some point that day, right?
yes.
When you came back the next day, was that there?
No, it wasn't.
It was gone.
Yes, it's on.
And did you see Alex Murdaugh leave after he went upstairs? Do you know what he did upstairs?
No, no.
Did you actually see him leave the house after he went upstairs?
Yes.
And where did he go?
Oh, I don't know. He just left outside and left.
Okay. Did he say, hey, I'm leaving?
Yes, he said I'm going, yes.
And at that point, what did you think? Did you think he'd gone?
I thought he left, yes.
Okay. Did you see him after that?
Yes.
Tell them where, please.
He came
That
back.
morning.
He came back to the house.
And how do you know that?
Interesting.
Because the blind was open, I seen him came through the driveway.
And what did you see him? Was he walking? Was he driving when you saw him in the driveway?
He was driving the truck,
And I'm sorry, Ms. Smith, what truck was he driving?
the white truck.
Whose white truck was it?
I'm thinking it was Mr. Randall. I thought it was his truck. He had the white truck also.
He had a white truck also.
Mhm.
So when you saw, you testified, Mr. Murdaugh coming back in a white truck, that was Mr. Randolph's truck? Whose truck was it?
I don't know.
And let's use words as opposed to, or because we need to know exactly what you're saying. Say yes or no if you can.
Whose truck did you think it was?
I thought it was Mr. Randolph's truck.
And were there four-wheelers or ATVs out on that property?
Yes,
Okay. What, if anything, had you observed about a four-wheeler that morning?
it was at the house,
Where had it been previously?
at the smokehouse,
When did it get moved?
the same day of that, the same morning.
Same morning when Mr. Murdaugh was there?
Yes.
And in what direction did you see Mr. Murdaugh leave? When you saw him leave the house and you thought he was gone? You know where he went?
No,
And when he came back in this white truck, what did he do?
he got in the other truck,
How long was he gone?
for about 10 minutes or 15 minutes, thinking.
And then you say this other truck. What truck are you talking about?
It was a black truck.
Had you not seen that before?
No,
Why not?
because the food truck, the catering thing was still out there anyway, so I couldn't see it.
So that blocked your view.
It's blocked my view, yes.
So what vehicle did Mr. Murdaugh leave after he came back in the white truck? What color truck?
It was a black truck. Black.
You know whose that was?
No,
That morning, this morning when you first saw him at 6:30, did you observe anything about his face? Any on his face?
they had like a little color, a little bruise cut or something,
And I apologize, a little what cut?
like a little bruise or something.
Where was it?
It's like above his forehead,
I won't ask you to touch me, but can you touch yourself to show where?
right here, something right there.
Did it look fresh?
This looked like a cut, not, I wouldn't say fresh, but it looked.
Was there a video system in the house for either Sister Murdaugh or Miss Libby Murdaugh?
Yes,
Can you tell them about that? Where was that? What was that?
it was in the Miss Libby's bedroom.
And how was that activated or operated? It's better. Do you know?
No,
Was it on all the time or not?
yes,
And what color would it be if it was on? Was there a marker that, or a red and black or red and green?
the surface, yes,
And would there be times when that wasn't on?
yes,
And do you know who controlled it?
no.
Get the helmet. I'm going to show you what's marked 410. Do you recognize this?
Yes.
Okay. And does it relate to what we're talking about this morning as far as your location?
Yes.
Your Honor, 410, I believe without objection.
Says it relates.
Her testimony, where she was at.
Okay. No objection.
So admitted. Without objection, it's submitted.
Can you see this on your, you got a little thing up there? Do you mind coming down here? Judge, can she come down here?
Yes.
Very briefly, it won't be long. If you would stand up there, so just we don't block the jurors, please, so Mr. Griffin can see. Is this a picture of what we refer to as Alameda?
Yes.
And can you show where the, I guess I've called the main house? And I'm sorry, we don't have a pointer. That's the main house. And you have to say yes for the record, please, ma'am.
Yes.
And down here, I know it's hard to see. Can you tell where that is? Sorry. Can you point to the main house again? I think you blocked the jurors. That's all done. Is that where you took care of Miss Libby?
Yes.
Okay. Now down here, there's even a little O on it. Do you know what this is down here? Let me ask you this, what other buildings are on the property?
The smokehouse and a barn, another little shed.
And where were the ATVs usually?
At the smokehouse.
Where's the smokehouse?
That's it. Yeah,
There you go. That's the smokehouse.
Mhm.
And that's where the ATV
Shed.
was.
Yes.
And where did the ATV
Let's see if I can get a picture
end up
of the
when you
entire
saw it
property
after you
aerial
talked
so we
to
can kind
Murdaugh?
of see what's happening at the same time
And
here.
it moved?
At the main house.
Say that again, please,
At the
ma'am.
main house.
Okay. And when you saw him coming back, you thought he'd left. Where did you see him in the white truck? Do you remember?
All right.
He left me across the railroad track, you know. He left me across the railroad track and went out.
Which way the railroad tracks?
This way, I mean, that's the house. So had to been around, just had to drive through.
You're not going to say anything, but speaking up.
I'm trying to.
That's good. Go back and sit down. That's fine. Thank you.
Yeah, bear with me. I'm going to pull up a the Moselle farm, I believe is what they call it. It's the Murdaugh family farm. And okay, here we go. It's a matter of finding one that has the full, like the full farm in it. It's kind of a little bit of this, a little bit of that. So.
Now, have you talked with either Mr. Griffin or Mr. Harpoon or one of their investigators?
Yes.
When was that?
Oh, I haven't remember.
Best you remember. I'm not looking for a date and time, but you know how long ago?
It was last year.
And I met with you a couple of weeks ago?
Yes.
And just a little while ago this morning?
Yes.
And I have to ask you for the record, this Alex Murdaugh who came and saw you the night of the murders with the shorts and the shirt and the Sperry type loafers on, is that him over there?
Yes, sir.
And is he also the person that you said told you he'd been there 30 to 40 minutes?
Yes.
And is he also the person you saw in the house that night with some kind of blue vinyl that you said consistent with this picture we put in? Is that him?
Yes.
Thank you, that's all.
I'm fighting it, guys. I'm fighting it.
Good afternoon, Ms. Smith.
Good afternoon.
If we have met once or twice, did anyone ever show you a blue rain jacket?
No, that. Yes, I think so. Yes.
Now, some of our investigators showed you a picture of a blue rain jacket.
Yeah,
correct?
picture of it, yes.
But has anyone at SLED or the Attorney General's office ever shown you a blue rain jacket?
No.
Now, you saw Mr. Alex Murdaugh bring a tarp in, you said, right?
Yes.
And I'm going to show you a tarp, which we marked for identification purposes. This is, Your Honor, Exhibit 86. Is this the type of tarp that Mr. Murdaugh came in to the Alameda house on the day that you were talking about?
Yes.
Tarp like this that would maybe cover up a car. Is that right?
Yes.
Any way to confuse this with a rain jacket?
No.
He was not carrying the rain jacket, was he?
No, it was balled up. I don't know it.
And you said it was balled up, and it was balled in such a manner it did not look like there was a shovel handle, a gun, or anything. It's just balled up. Is that right?
Correct.
Have I balled it up sort of correctly?
Yes.
All right.
You ball up that voice of yours, man. That is just his.
Move.
Gives me a headache hearing that guy.
Exhibit 86, I think, and evidence.
Excuse me, sorry, me to endorse into the mic here. My bad.
Now, when Alec left that day, this was laid out on Ms. Libby's retirement rocking chair, wasn't it?
Yes.
Okay. And you had, and when you left for end of your shift that day, that's where it was, right?
Mm-hmm. Yes.
And you've never seen it since, correct?
Correct.
Now, they showed you a picture, which is in evidence. Do you even know where that picture was taken in the house?
No. In the closet.
Do we have that picture? What's the last photograph that went down?
That's a huge property they've got, though. Like as I'm looking at it here, it's pretty massive. Is this the Zillow? Ooh, you know, let me go. Let's take a step further. We're gonna go a little bit deeper into this. Yeah, I'm with you, Cindy.
Can you see that, Ms. Smith?
Yes.
Do you know where that is in, or even if it is in Ms. Libby's house?
I couldn't say because I don't go in. I don't be in the closets. I don't know.
So you don't even recognize the closet, is that right?
Correct.
And have you ever even been upstairs in Ms. Libby's house?
Twice.
2 times over how many years?
3 years.
2 times in 3 years. And do you know where Alex Murdaugh went when he went upstairs on the day that he brought a blue tarp in the house?
No.
Now, you mentioned that this day that he came over was about 3 days after Mr. Randolph Murdaugh's funeral. Is that right?
Yes,
Okay. And it was early in the morning?
yes,
So, and do you remember that Mr. Randolph's funeral being on a Sunday?
yes,
So then it would be Monday, Tuesday, Wednesday of that week. Is that right?
yes,
Okay.
that's correct.
And is that the morning that you said that you thought you saw a bruise on his forehead?
Yes,
So it was Wednesday after Mr. Randolph's funeral?
I'm thinking, I can't remember. It's so long, I can't remember.
Yes, ma'am. And and you mentioned that that he came in a truck. I think you said he drove up in a white truck.
Mm-hmm.
Is that correct?
Yes.
And he does have a white truck, as
Yes.
far as you know, right?
Yeah, yes,
And then you said he left in a white truck. And are you sure that it was Mr. Randolph's truck or Mr. Alex's truck that he left in?
because it was moved. Mr. Randolph had always keep his truck in a certain position, certain part.
So you think he left in Mr. Randolph's truck and moved?
Yes,
Okay. And when you came back, when you left that morning, I guess Wednesday we're talking about, was Mr. Randolph's truck back in the driveway,
yes,
parked in its normal place?
yes,
Anything out of sort?
no,
Was it all covered up with mud, like someone's been mudding in it?
no,
Anything unusual about the truck?
no,
Now, you mentioned there was a four-wheeler that had been moved at some point in time. That four-wheeler had a flat tire, didn't it?
yes, it did.
And was it a front tire, back
I
tire?
think it was a back tire.
And it was moved up close to the house,
Yes,
far as you know, so the tire could be repaired
yes, it was moved from the smokehouse to the wreck house. Yes,
with a flat tire.
yes, with a black tire.
Now, you were asked questions about the day of Mr. Randolph's funeral. And you had a conversation with Alec, and he's talking to you about how long he was over at the house on the night of June the 7th, right?
Yes,
And he said he was there 30 to 40 minutes.
yes,
And you said, no, I don't think it was that long.
yes,
And then the next day, I think you said, or day after, well, the following day, or I guess that would have been Monday, you had another conversation with him where you just brought up back that you were going to get married. I think you said that was a different day, right?
yes,
And he was just being nice, wasn't he?
yes.
I think you used the word good person.
A good person, yes.
Who were you referring to when you testified in response to the question by Mr. Meadows that someone's a good person?
Mr. Alex Murdaugh.
Now, he came over on the night of June the 7th. And you said it was somewhere between 8:30 and 9:30 in the evening.
Yes,
And that's just your best estimate of when he got there, is that right?
yes,
And I think you testified that he was there, in your estimation, 15 to 20 minutes?
yes,
Now, when you said 15 to 20 minutes, are you talking about 15 to 20 minutes in the room with Ms. Libby or on the property the whole time?
been property the whole time. Thank you.
Okay, well, now you said it took you about 5 minutes to let him in, is that right?
Yes,
So are you including the 5 minutes it took you to let him in your 15 to 20, or could he have been on the property 25 minutes?
20 minutes, only thing is,
No.
The whole time, so.
And you would agree that Alex Murdaugh would visit his parents frequently, right?
Yes,
And he would always come over more so than any other sibling. Is that right?
yes,
And you would agree that it was not out of the ordinary for Alec to come at night, correct?
yes.
You would agree with that, right?
No,
So you don't agree that is, so was it out of the ordinary for him to come at night?
yes, on my shift, yes.
Well, do you recall being interviewed, a telephone interview on June 17th, 2021 with Agent Joe Albiado? You remember that?
Yes,
And do you remember telling him that it was not out of the ordinary for Alec to come at night?
yes, it's been long, and I couldn't remember. It's been a year now, so I can't really remember.
I mean, is it possible that you told him that?
Yes,
And here today, you said, as I have in my notes, that when he came over, that he was acting kind of fidgety, yet normal. I believe that's what you said. Is his normal behavior kind of fidgety?
yes,
He's just kind of a fidgety person, right?
yes.
So it wasn't the first time you'd seen him being kind of fidgety, right?
But he always come different times, so I can't,
But his demeanor was normal for Alec the night that he came over on June the 7th, wasn't it?
I'll say yes.
Okay. Now, you mentioned the clothes that he was wearing. And he came in and he sat on his mom's bed,
Yes.
lay down next to her,
Late.
and held her hand. Is
He
that
walked
right?
in and hold her hand and spoke to her, then went on the bed and lay down.
And lay down.
Not lay down, but sit up.
And when he got up off the bed, was the bed soiled in any way? Was it wet?
I can't recall that. I didn't touch it.
Okay. What did Alec Murdaugh have blood on his clothes?
No.
He had blood on his shoes.
No.
He had blood on his hair.
No.
Did he leave blood in his mom's bedroom?
No.
Now, according to the records that we've been providing in this case, you were interviewed by SLED on June 16th. Do you remember that interview?
Yes.
And I think in that interview, you told SLED that he had been there 30 to 35 minutes. Do you remember telling him that?
I think it's, yes.
And then you were interviewed again by telephone on June 17th. You remember that follow-up call? You remember having a short phone call on the 17th?
A phone call.
Okay. Well, whether it's one interview or two interviews, you never told anybody at SLED in June in these interviews, one or two, anything about Alec coming in with a blue tarp. Is that right?
Right.
You didn't say anything about a blue tarp until sometime in September. Is that right?
Yes.
And you initially mentioned something about Alec coming over with a tarp. The first time you mentioned it was to Officer Joseph Dingle of the Allendale Police Department when he was working a wreck. Do you remember that?
Mm-hmm.
Is that yes?
Yes.
Okay. And you had been in the automobile accident, and Officer Dingle was working the wreck, and I guess, filling out an incident report, and you were having a conversation with him.
Yes.
And in that conversation with Officer Dingle, didn't you tell Officer Dingle that on the night of the murders that Alec came over with a blue tarp that looked like it had a gun in it?
No, I saw him like he was holding something.
So you didn't say?
I didn't say specific it was a gun. I said he was holding something.
So you didn't tell Officer Dingle that he came over and you couldn't tell, but stated it looked like a rifle?
No, I said it was like he was holding something. I did not say it was a rifle.
Okay. And if Officer Dingle wrote a report up saying that, he was just incorrect?
Yes.
Okay. And then after you had this conversation with Officer Dingle,
you can do
then you
better.
were contacted by SLED agents, right?
Mm-hmm.
And they asked you to go down to their offices, and that's where you were interviewed in September, right?
Yes.
And in that interview, you told them about a blue tarp that you put over your car just like this, right?
Mm-hmm.
Is that correct?
Yes.
Okay. And you didn't tell them because it's not true that there was anything wrapped up in here to look like a rifle.
Right.
Okay. And since that day of the interview at the Low Country SLED office, have you had any additional interviews with SLED agents other than getting ready for trial last week?
Yes.
How many additional interviews?
Two or three.
And in each of those interviews, did you reiterate to SLED that it was a blue tarp and not a rain jacket that you saw Alex Murdaugh walking into the house with?
Yes.
Is there any doubt in your mind it was a blue tarp like this and not a rain jacket?
And it was followed up with a blue tarp.
So you saw it laying on Ms. Libby's retirement rocking chair, right?
Yes, yes.
Second, Your Honor. Just one more point. When Alex Murdaugh came over on that early morning, I guess it was Wednesday, you testified. Were you in Ms. Libby's room?
Yes.
And you can't see the comings and goings out of the driveway from Ms. Libby's bedroom, can you?
Mm-hmm.
You can?
No.
Okay. Thank you, Your Honor. That's all the questions I have.
Redirect.
Testifying in front of the grand jury on January 20th of 2022, on page 25, line 17, when you were asked about how long do you think he stayed in total, do you remember that?
Yes.
Do you remember your answer being 20, 10, 15, 20 minutes?
Yes.
Mr. Griffin asked you about the 30 to 40 minutes. Why'd you call your brother after that?
Because he's a chief, assistant chief police at Ronville. So I called him.
Had that statement by Alex Murdaugh affected you?
Yes.
How?
I was nervous.
And Mr. Griffin asked you about the evenings visits and the morning visits. Had he ever been there at 6:30 in the morning like he was that morning? Ever?
No.
And his 9:30 visit the night of the murders, that was very unusual for him to be at night, wasn't it?
Objection, leave.
Don't leave the witness.
I'm sorry.
Yes.
Was that unusual?
Yes.
Now, so you told an officer, did you tell an officer about this? You saw something that he thought he was carrying
Yes.
before you told anybody else?
Yes.
And what was that about, a traffic accident?
I had someone hit my car. He was on duty.
And when was that?
September 11th.
That's my birthday.
Okay.
You had an accident, and you told the officer that you had seen him, Alex Murdaugh, come in holding something?
We was talking, was having a conversation, and that came up.
And you just told him that?
We was talking.
Had anybody asked you that before?
Mhm.
You have to say yes or no.
Yes.
Had
No,
anybody asked
no,
you that before?
no.
Okay. So why did you tell the officer that on September 11th?
We was having a conversation and just talking in general. And he asked me a question. And I said, yes, I've been there. And I said, I work with the Murdaughs. His mother.
In response to him, you told him you saw Alex Murdaugh with what?
A lining, a blue tart.
And you saying tart or tart?
Tart. Like a cover car with a tart.
And you said you saw him with that, and did it appear he was carrying something?
Like he was holding something. It was bundled up. It was bundled up.
Bundled up?
Yes.
Like this?
Yes.
So you never saw this unfolded?
No, I never saw it.
Never?
Till the next morning, that was on the chair in the biggest room.
And you don't know where this tart came from, do you?
No, I don't know where it comes from.
And it didn't have silver on one side, did it?
No.
It was all blue?
All blue.
And you said that the defense took a statement from you?
Yes.
Did they report it?
Yes.
John, under Rule 613, I'd like a copy of that statement or the recording at this time, if they have it. She's now taking the stand.
Your Honor, under Rule 5, it is not subject to being produced. And we didn't question her about the statement, so.
Rule 5 is pretrial.
Under 613, I think once the witness has taken the stand and she said that they took the statement from her, either recorded or written, we don't have it, hadn't been provided. He asked her about that specifically, dealing with the blue tarp, and when they discussed it with him, I'd like a copy of it.
I actually don't mind him having it, Your Honor. We don't have a copy with us.
Rule says upon request, the same shall be shown or disclosed to opposing counsel pursuant to Rule 611A. So the defense must provide it to counsel.
Your Honor, we do have a copy here. I don't know if we can download it to, yeah?
Yes. Is it okay to produce it on flash drive? Judge, I mean, I can't look at the flash drive, but yeah, I guess. Is it a hard copy?
Not a written statement, it's an audio recording.
Opportunity to listen to that without the presence here. I'm assuming it'll be a hard copy, but I don't want to mess the court schedule up either.
Now, ladies and gentlemen, we'll have you go to the jury room. Please do not discuss the case.
Okay. This is a good moment for me to go ahead and make a correction, guys. I had said earlier that Paul Murdaugh was not charged with anything. Well, he wasn't actually officially charged. Well, he wasn't actually found guilty of any crime because he was killed while awaiting the trial. But he was charged with, I believe, a manslaughter charge. And while he was awaiting that trial, that's when he was killed, allegedly, by his father. So I had to make a correction earlier. I said that he wasn't charged with anything, but he was charged, but not found guilty. So I can do better. I'll do better, I promise. But that's the case there. So he, was away. But the issue is that he never spent 1 day in jail. He never spent 1 second in a jail cell. Even his booking photo was taken in the courtroom, where they walked him in, they read the official charges, and then
We'll get these momentarily.
we're going to handle this bond right now. We're not going to, send him to jail for a day or half a day or 6 hours or 2 hours while we, pay this out. Basically, the family was like, no, we're gonna go ahead and settle this up right now, get this all squared up. Yeah, so I pulled up some pictures here that we're going to look at real fast. So hopefully you guys can see this all right. So this is a picture of like the dog kennels, the the outlying area where, and I believe this is typically you see an aerial shot, but this is where the mother and son where Paul and his mother were shot and killed, here in the out in the barn area, the outlying area of the property, which, like I said, is a 1,700 acre property. It's massive. So there's a lot of area to cover in this. And then this next one, this is interesting. Look at this, guys. So this is the front of the house, right? Now they said that the housekeeper, was that died, that fell down some steps, and was dead, pronounced dead on scene. They're like, oh, did you try life-saving the 911 call is interesting. They asked Paul if he had tried any life-saving techniques for resuscitation. He's like, no, she's dead. She's dead. He was just like, nah, why would I do that? So, yeah, this is those steps right there. I mean, there's not a lot to them. You know what I mean? And apparently she was knocked on the steps by their dogs, their hunting dogs that weren't allowed in the house, that were not, up in that area ever. So, and you can see, like I said, back here, this is where the dogs would have been. But somehow they were up here in front of the house, knocked this lady down the steps who had been there multiple times. It wasn't like her first rodeo. So you guys, there's been so many things around this family, around this case that go back way before just the killing of Paul and his mother. Apparently, my associate has some pressing information that I feel I should check into for a brief moment. So, give me a second.
Please proceed.
Well, let's see, if you need a half an hour to listen to this tape, we can take.
We have a rough draft of a transcript that we're emailing to them but it's 57 pages long, but we're sending it to them.
A rough draft.
So I'd like to look at the video at this point.
All right, we're going to bring the jury in and break for lunch.
While they're sorting that out, you guys, I'm going to go ahead and pull this news here about the earthquake in Turkey and Syria. Yeah, you guys, yeah, it's crazy. So the charges against Paul Murdaugh, this is the son that was killed, in the death of Mallory Beach have officially been dropped. The South Carolina Attorney General's office confirms to a local news station. Murdaugh was charged with 2 counts of boating under the influence causing bodily injury and 1 count of BUI, boating under the influence, involving death in connection with Mallory Beach's death in 2019. He had pleaded not guilty to those charges. Though the reports do show that Murdaugh's blood alcohol level was triple the legal limit when the boat hit a piling in Archer's Creek, throwing Beach and several others from the boat. Beach's body was found 7 days later. Now, what's really horrible about this too is the kid was 19. He used a fake ID of his brother's to buy the alcohol. And on another note, the crime scene or the incident scene was roped off, and no one was allowed down to where that accident happened, where Mallory Beach's body might have been while they were looking for it. So her parents were there, and they weren't allowed to go down to where this happened. They weren't allowed to be a part of it. When Alex Murdaugh showed up, however, and his attorney, they opened up the caution tape was parted, and they ushered him right in. So they were able to go down. And then if you watch any of the CCTV from like the hospital and some of the accounts from Paul's friends, he was bouncing basically courtroom or from hospital room to hospital room, trying to get his friends to take the fall for driving, basically saying like, do you really even know who was driving the boat? Or are you aware of who might have been, in control of the boat?
All right, thank you. Ladies and gentlemen, we'll break for lunch till 2:30.
I need to take the fall. I need to say I'm guilty of it.
30.
It's pretty wild, man. And his friend was, if you watch the dash cam footage and the police guy, he was screaming at Paul, he's like, get him away from me. He's like, you killed her. It was Mallory Beach's boyfriend, who was one of Paul's best friends. The whole thing is just
729. I'll speak with you during lunch.
before that, even though,
So
with the death of a young
return to
man,
the jury room, please.
they just like to get these people up and up, up and out, up and out, up and out. I like how the witness, she said, my grands. She had 6 grands, but they like to get these people shuffled around. But with the death of a young man who was having same-sex relations apparently with one of the Murdaughs, and was found dead in the middle of the street in a very, again, another odd, unsolved. They say that it was I believe it was deemed as a suicide. Is that correct?
We're going to take a break for lunch.
Yeah,
You just cannot
the
discuss
young-
your
the gay kid
testimony
was
with
found
anyone during lunch, but you can step down.
They said it was a hit and
Have a
run.
good
Sorry,
lunch.
yeah. So it was an unsolved hit and
We
run.
will be in
They look at the crime scene.
2:30.
Looked like the kid's head was basically beaten in with like a 2x4 or something along those lines. But the case was reopened recently, so I appreciate that. Yeah. So it's just one of these things that where as we're watching these things take place, we're hyper aware of the fact that this family has had some influence. And oh man, I got my beanie popping. I was like, what is that thing behind me? That's crazy. What's that thing behind me? What? All right, now let's take a look at. I'm just going to pull it up on my my page over here, so you can take, so we can see it together here. So I went ahead and put up a post on my Facebook page here at CJTV Media, or if you're following me over at CJ Halliburton over on my personal page, either way, good to go there. But they're at a lunch break right now, so I'm going to go ahead and let everyone know here what's going on. Court will return from lunch break. 2:45. Nah, let's edit that. Court will be on lunch break until.
Court just went on a lunch break in the murder
I'm just
trial
gonna say
of
this.
disgraced
Court's
attorney
online.
Alex Murdaugh. Lots happening already on this Monday. The first
Yeah.
witness of the day was caregiver Shelley Smith, who took care of Murdaugh's mom, and she had some very interesting revelations. Let's hear from her testimony earlier, and then we'll discuss it.
When you got there on June 7th of 2021,
No, let me,
shortly before 8,
We just watched this testimony of
In the bed.
the caregiver. So,
caregiver.
excuse me. Hey guys, I apologize. I'm fighting a cold over here, so bear with me if I'm coming in a little froggy. But I'm gonna go ahead and show you. I hate when people just read me things and I don't know what I'm looking at. I don't want you to just have to stare at my fat face. So I'm gonna pull this up for you as well, and give you a look at what I'm talking about here. So, boom, there we go. So, as we look at it here, and keep in mind, you can see it links to all of the other locations where you can find me here. So, let me zoom in on this here. Hopefully, this will give us a. There we go. Ooh, there we go. Almost excessive. So these are notes to know 2 weeks into the trial as we're moving into it. We're on day 9 now. These are the first 7-8 days of the trial. We know who he is. We know what he did or what he's been accused of. The growing list, they have called over the 20 witnesses out of 255 potential witnesses. Mark Tinsley testified. That was, if you guys want to watch the beginning of the tape from today, we're going to do part 1, part 2 probably, or if we just run one solid for today, it'd definitely be interesting to watch. It's one worth watching because he definitely put the screws back on the defense attorneys who were really trying to kind of give him the business, but the guy was taking no nonsense, really kind of like a no shit type of lawyer, Judge Clifton did hear some other arguments over the course of the last 2 weeks, including different evidentiary findings and including the financial crimes, which are over 100 financial crimes, totaling up to almost $9 million that are teamed against Alex Murdaugh right now. But here we go. As we move into it, what to know, the SLED agent testified that Murdaugh said, "I did him so bad." Now, that was some controversy when the case first started, because what they're trying to say is that what they're trying to say the recording said was they did him so bad, and what they're talking about is his son, and how gruesome his death was. And if you didn't catch it, man, day 1 they were talking to the officer and some of the people, the first responders, about what they saw, and it was gnarly. I mean, they were talking about where his brains were located in the ground and just some of the things they saw. The guns that were used were no there were no like pew pew type pistols. They have the missing guns right now. Were coming out of a blackout 300 blackout caliber weapon, which is basically an AR-15, modified AR-15, which was made by the cousins, two of them. And this comes into the trial as well. A shotgun and the AR-15. There are guns missing from the Murdaugh family arsenal, right? Which, if that doesn't tell you something, that you're not seeing the facts. So, and that's kind of what they talked about with even the caregiver, with the fact that, and we'll just look at it real quick here. He was saying it was so bad, I did him so bad. The Murdaugh attorney Jim Griffin played the video again at a normal speed, at 1/3 speed, and asked if it wasn't clear that Murdaugh was saying they did him so bad. So there's that controversy there. And the prosecutors, they don't have the murder weapons. There's the other thing we're dealing with right now, that 300 blackout caliber weapon that was used to kill Maggie Murdaugh. And prosecutors have suggested that she was killed with a family weapon, right? Which they have the shell casings and and of course you're going to have to go with the ballistics on the wounds themselves were they were in line with the weapons that the Murdaughs had in, registered weaponry. Also, they said there was several other blackout caliber weapon rounds that were found all throughout the property, as well as other shotgun casings. Mind you, this is kind of a hunting property, so you're going to be out there shooting off guns in 1,700 acres, doing what you're doing. You got kids, kids and guns. Why wouldn't you? It's always a great combination, as we've seen in the news today. I'm obviously being facetious. It's terrible. Now, the John Bedingfield, the Murdaugh's second cousin, did testify between 2016 and 2018 that he custom built these 300 blackout caliber rifles to fill an order that the Murdaughs had made. However, they are missing. I don't know. That seems pretty heavy duty as far as evidence goes right now, that the weapon that was probably the weapon caliber casings found in ballistics, reports state is missing, and it just happens to match up with weapons that were found at the Murdaugh family arsenal. So the cell phone data. Now, this was interesting. They have they had a witness come in from Snapchat that actually testified about the trial, about the snap that was found, which, as the hip kids know, is a note or comment or post made on Snapchat, which is a trash bag site. I'm just going to say it right now, contrary to what others might think. But the cell phone data traces Maggie and Paul's last communications, and they trace them to the farm or the family estate. Paul Murdaugh they're saying Paul Murdaugh was killed at about 8:50 and Maggie Murdaugh soon thereafter. The state called cell phone forensic experts to testify about who they communicated with before their deaths. Now, Maggie and Paul Murdaugh both read text messages for the last time around 8:49, within a minute of her parent death. But Lieutenant Britt Dove, a supervisor at SLED's Computer Crime Division, testified someone held Maggie's phone in their hand at 8:54. Right. So they're saying 4 minutes after her apparent death, and again at 9:06. So the records also showed 5 missed calls from Murdaugh between 9:04 and 10:03. Murdaugh called 911 around 10:07 to report finding the bodies of his wife and son. Maggie's phone had no other activity that they found and then they found the phone the next day about less than a mile away from the family farm. Now, the Snapchat video places Murdaugh at the crime scene. Paul's best friend Rogan Gibson testified Wednesday he was 100% sure the voices in a video found on Paul's cell phone taken about 8:40 the night of the killing belonged to Paul Murdaugh, Maggie Murdaugh, and Alex Murdaugh. That puts Murdaugh in a place he says he never was. Mind you, he said he was off visiting his mother and he hadn't seen the two of them since supper, right? Which is what they say in the South. Some say dinner. Other people call it hot dog and tater tots, wherever you're at. But he says at the time he wasn't present at the night of the murders. Murdaugh told 911 operators and SLED investigators the last time he had seen his wife was roughly 2 hours before the killings, right? So now we're seeing the Snapchat, and he was like, no, I'm 100% certain that was Alex Murdaugh speaking in this Snapchat, and that video pulled up, and you guys, I showed you a little clip of it earlier. Paul's friend Will also testified about a Snapchat video Paul sent him at about 7 p.m. that briefly shows Murdaugh wearing a long pants and a short sleeve shirt, different clothing than what he was wearing when the officers arrived at the murder scene, which was black shorts and a white t-shirt. And those clothes, I believe as of right now, are yet to be found. So the potential outfit that he was wearing when the murders took place aren't anywhere to be found, and they weren't the same thing he was wearing when he talked and was interviewed and interrogated in the police cruiser, which you can see the dash cam footage of that. But the witnesses do testify about Murdaugh's alleged family crimes or financial crimes. And there's tons to go in on that. And I'll let you read up on that on your own. Moving into it, though, these are some of the keynote evidentiary findings that we found that have kind of played into the judge finding that this is definitely grounds for a trial, that there is plenty of evidence to prove that there was a crime committed, and that now it's going to be up to the prosecution, which is where we're at right now, to prove beyond a shadow of a doubt that Alex Murdaugh is in fact guilty of the crimes that he's being accused of. If you are interested in reading any of that or taking a look at the trial from today, you can always go into YouTube and or Facebook at CJTV Media LLC. We got a Snapchat as well, or not Snapchat, sorry, Twitter as well. You can take a look at it if you want to go back into the trial, because we're probably going to make a quick cut while we're in between, while we're on lunch right now, and then come back up once lunch is over. So it'll give you a chance to kind of review some of the earlier testimonies from today, which I definitely encourage you to do, and also share the stream out. You're going to want to do that because I'm sure there's plenty of people that are interested. So that being said, the reason for it all, who knows what's going on, but one of the things that is interesting too, and I'll read this here. Murdaugh called, okay, report Maggie and Paul. Where are we at here? One of the things, and I'll read it verbatim, is in a shocking turn of events, Murdaugh was shot 3 months later. This is after the death of his son and his wife, while changing a tire on a rural road. Authorities quickly unraveled a murder for hire plot that would allow Murdaugh's oldest son to receive a $10 million insurance payout. Curtis Edward Smith, the alleged gunman and former client of Murdaugh, is accused of conspiring with Murdaugh. The duo were indicted in an alleged scheme on November 2021. So all of the things that have happened around this trial, like all of these horrible things that have happened, the death of Paul and his mother, and then, which is terrible, are clouded with mystery, right? And then you go back before that, the death of their housekeeper, who had worked there for, I believe, it was somewhere in the range of 10 years, maybe 10 plus years, mysteriously fell down some steps and died at the paws of their hunting hounds. Go back in that same, all this range, we have the death of their friend on the boat where Paul was driving a drunk, and so all these things are taking place around this trial, and there's all these, I don't want to say conspiracy theories, but ideas as to who, what, where, and why. Like, why would somebody want to kill Paul? And there's all these streams that would go towards revenge for the death of the young woman who was killed while he was boating. Then there's the to draw attention. You go back to the other side of it, where maybe it was just done by Alex Murdaugh to draw attention away from all the crimes that he was being charged with on the financial side, with the near $9 million worth of fraud, embezzlement, and all the other charges. And it just doesn't stop with these people. And what's really terrible about it is you saw the first or the witness today, and she was testifying, and someone mentioned that she looked terrified. She looked super scared. And thinking about it, going into it, like, if you haven't watched any of the true crime documentaries, and I keep pushing this HBO one because it's pretty on point. It's a 3-part miniseries, docuseries. It's, I think, like 45-minute episodes. So episodically, it really kind of walks you through what happened and gets you currently up to point. But one of the guys that was in a narration standpoint was saying that people just never argued with the Murdaughs. If something happened, you just kept quiet or you went away. And it's wild that they talk about this witness, mentioning that she was getting married soon. He's like, oh, well, weddings are expensive, aren't they? And they're saying, like, he was just being nice. But at the end of the day, it's easy to be nice and also ask for some kindness in return, like saying, I've been here for a half hour. When they ask, that type of thing. And so that heavy lean is already starting in the trial, and you're seeing evidence that he was, we're calling it what it is, that he was already trying to control the narrative of the trial before it even started. And that's coming from a very experienced trial lawyer. So Alex Murdaugh is no foreigner when it comes to how to litigate a case. He definitely knows how to do things. He's been incredibly good at it. His family has a legacy of doing just that. They've been in the DA's office for generations. So this is not a foreign ground for them. Not to mention the fact that they have had their hands, we'll say, in the pockets of the police departments and other counties, surrounding counties. So yeah, it's easy to get nervous when it comes down to dealing with this family. Even the kids have had kind of like the golden road laid out in front of them. They've been able to get away with whatever they want, as we've seen with the hit and run death of a young man who was apparently having homosexual relationships with one of the Murdaughs. So if you guys are interested in a real true crime case, this is definitely the one to jump into. Because who knows, this could, by all stretch, it could go the other direction. We see all this evidence that's pointing towards a guilty verdict. Who knows? What if they just, in some weird glitch in the system, they say, well, actually, this evidence is going to be thrown out, kind of like what Mark Jensen was trying to accomplish. And then they do find him innocent and he walks out. A question was posed to me, though. So since the charges have been dropped against Paul Murdaugh because he's dead, there was a bond that was posted for his release so that he didn't have to spend the time in jail between when he was charged with the crime and when he would have gone to trial. Was that bond returned? Anybody who has any kind of like bond information, I'd be curious to find out where that money went, because I don't know exactly how much it was, but I know it wasn't little, because they were looking at a case involving the death of another human being. So curious to know. I'd like to find out. In between now and when that happens, you guys, we are going to cut out for a quick break. We'll probably take 30-40 minutes just to give us some breathing room when it comes to that 8-hour mark, because these trials tend to run a little later and they are on East Coast time. So for those that are out there enjoying that 1:30 lunch break, great. Everyone on the West Coast right now that's kind of jumping in here mid-morning, hello, and we'll see you soon. So don't be a stranger and don't be shy. Share the stream and say hello, and I'll be back with you guys here and in just a little bit. So take care. See you soon. Seriously, I'm doing it right now. I'm hitting the button.